Welcome to episode 42 of the Supreme Court Opinions Read podcast, where we read Supreme Court opinions so you don't have to. My name's Bailey, and I'll be reading the Supreme Court's opinion in Louisiana versus Callais, or as you may have heard of it, the Voting Rights Act case. The case was decided April 29th, 2026. And as always, we will begin with the syllabus. These cases concern whether Louisiana's new congressional map is an unconstitutional racial gerrymander. In 2022, after the state redrew its congressional districts, a federal judge in Robinson v. Ardroin held that the 2022 map likely violated Section 2 of the Voting Rights Act of 1965, 52 U.S.C. Section 10301, because it did not include an additional majority black district. But when the state drew a new map, SB 8, that contained such a district, the new map was challenged as a racial gerrymander. A three-judge court in Callais v. Landry held that SB 8 violated the Equal Protection Clause of the 14th Amendment, and the state appealed to this court. The parties originally briefed and argued this suit last term, and their arguments at that time highlighted problems in the existing body of Section 2 case law. One problem resulted from the rule that in racial gerrymandering cases, unlike other cases involving claims of racial discrimination, strict scrutiny is triggered only if race predominated in the state's decision-making process. Another problem stemmed from the long unresolved question whether compliance with the Voting Rights Act provides a compelling reason that may justify the intentional use of race in drawing legislative districts. For over 30 years, the court has simply assumed for the sake of argument that the answer is yes. These and other problems convinced the court that the time had come to resolve whether compliance with the Voting Rights Act can indeed provide a compelling reason for race-based districting. Held. Because the Voting Rights Act did not require Louisiana to create an additional majority-minority district, no compelling interest justified the state's use of race in creating SB 8, and that map is an unconstitutional racial gerrymander. Part A. The Constitution almost never permits a state to discriminate on the basis of race, and such discrimination triggers strict scrutiny. The court's precedents have identified only two compelling interests that can satisfy strict scrutiny: avoiding imminent and serious risk to human safety in prisons, and remediating specific identified instances of past discrimination that violated the Constitution or a statute. The question presented is whether compliance with Section 2 of the Voting Rights Act should be added to this very short list of compelling interests. The court now holds that compliance with Section 2, as properly construed, can provide such an interest. A proper interpretation of Section 2 requires examining the statutory text to understand what it demands with respect to drawing legislative districts. Section 1. Under Section 2A, the court takes as a given that a legislative districting map may constitute a standard practice or procedure that may violate Section 2 if it results in a denial or abridgment of the right to vote on account of race or color. Section 2 establishes that a violation occurs when political processes are not equally open to participation by members of a racial group, in that they have less opportunity than other members of the electorate to elect representatives of their choice. The key concept is less opportunity than other members of the electorate, which sets a baseline against which to assess the opportunity of minority voters. That baseline, the opportunity that any given group of voters has to elect their candidate of choice, depends on the voting preferences of other voters in the district. For example, in a district where most voters prefer Democratic candidates, a Republican voter in that district will have a low chance of securing the election of his or her preferred candidate. The roster of voters who end up in a given district depends, in turn, on the districting criteria the state uses to draw a legislative map. Thus, the opportunity of these members of the electorate to contribute their votes to a winning cause is whatever opportunity results from the application of the state's combination of permissible districting criteria. That is what a randomly selected individual voter and group of voters can expect regarding their opportunity to elect their preferred candidate. Under Section 2, a minority voter is entitled to nothing less and nothing more. Section 2. This interpretation is the best reading of the statutory text and ensures that Section 2 of the Voting Rights Act does not exceed Congress's authority under Section 2 of the 15th Amendment, which confers on Congress the power to enforce the amendment by appropriate legislation. As the court has long held, the 15th Amendment bars only state action motivated by discriminatory purpose. So a law that seeks to enforce the 15th Amendment by prohibiting mere disparate impact would fail to enforce a right that the amendment secures. That is never appropriate because Congress cannot enforce a constitutional right by changing what the right is. For this reason, the focus on Section 2 must be enforcement of the 15th Amendment's prohibition on intentional racial discrimination. When Section 2 of the Act is properly interpreted, it imposes liability only when circumstances give rise to a strong inference that intentional discrimination occurred. Properly understood, Section 2 thus does not intrude on states' prerogative to draw districts based on non-racial factors, including to achieve partisan advantage. In short, Section 2 imposes liability only when the evidence supports a strong inference that the state intentionally drew its districts to afford minority voters less opportunity because of their race. Not only does this interpretation follow from the plain text of Section 2, but it is consistent with the limited authority that the 15th Amendment confers. Part B. This interpretation does not require abandonment of the framework for evaluating Section 2 claims that the court established in Thornburg v. Jingles. The court need only update the framework so it aligns with the statutory text and reflects important developments since the court decided Jingles 40 years ago. 4 historical developments are of particular note. First, vast social change has occurred throughout the country and particularly in the South, which have made great strides in ending entrenched racial discrimination. Second, a full-blown two-party system has emerged in the states where Section 2 suits are most common, and there is frequently a correlation between race and party preference. Third, in Rucho v. Common Cause, this court held that partisan gerrymandering claims are not justiciable in federal court, and this holding creates an incentive for litigants to exploit Section 2 for partisan purposes by repackaging a partisan gerrymandering claim as a racial gerrymandering claim. Fourth, the increased use and capabilities of computers in drawing districts and creating illustrative maps means that a Section 2 plaintiff can easily identify an alternative map that fully achieves all the state's legitimate goals while producing greater racial balance if such a map is possible. In light of these developments, the court updates the Jingles framework and realigns it with the text of Section 2 and constitutional principles. Section 1. The first Jingles precondition is that a community of minority voters must be sufficiently numerous and compact to constitute a majority in a reasonably configured district. While many Section 2 plaintiffs have simply provided illustrative maps with their desired number of majority-minority districts, such maps prove only that the state could create an additional majority-minority district, not that the state's failure to do so violated Section 2 of the Voting Rights Act. To show the latter, plaintiffs' illustrative maps must satisfy 2 conditions. Plaintiffs cannot use race as a districting criterion in drawing illustrative maps, and illustrative maps must meet all the state's legitimate districting objectives, including traditional districting criteria and the state's specified political goals. Section 2. To satisfy the second and third preconditions, politically cohesive voting by the minority and racial bloc voting by the majority, the plaintiffs must provide an analysis that controls for party affiliation, showing that voters engage in racial bloc voting that cannot be explained by partisan affiliation. Section 3. On the totality of the circumstances inquiry, the focus must be on evidence that has more than a remote bearing on what the 15th Amendment prohibits, present-day intentional racial discrimination regarding voting. Discrimination that occurred some time ago and present-day disparities characterized as ongoing effects of societal discrimination are entitled to much less weight. Part C. Nothing in Allen v. Milligan dictates a different result. That case merely addressed whether Alabama's novel evidentiary standard required a change to existing Section 2 precedent. Allen did not address whether race-based redistricting under Section 2 could extend indefinitely into the future despite significant changes in conditions. nor did it address whether Section 2 plaintiffs must disentangle race from politics in proving their case. Indeed, Allen did not address the 14th Amendment at all, but here, the decision before the court is based on the 14th Amendment. Part D. Under the updated Jingles framework, the facts of this suit easily require affirmance. Louisiana's enactment of SB 8 triggered strict scrutiny because the state's underlying goal was racial. The state configured District 6 to achieve a black voting age population over 50% because the Robinson Court held that Section 2 likely required the creation of an additional majority black district. The state's intentional compliance with the court's demands constituted an express acknowledgement that race played a role in the drawing of district lines. No compelling interest justifies SB 8 because Section 2 did not require the state to create a new majority-minority district. At every step of the Jingles framework, the Robinson plaintiffs failed to prove their Section 2 case. On the first Jingles precondition, the Robinson plaintiffs did not meet their burden because they did not provide an illustrative map that met all the state's non-racial goals, including the state's political goals. On the second and third Jingles preconditions, the Robinson plaintiffs offered evidence that black and white voters consistently supported different candidates, but their analysis did not control for partisan preferences. And on the totality of circumstances, the Robinson plaintiffs failed to show an objective likelihood of intentional discrimination, instead relying on historical evidence and evidence that failed to disentangle race from politics. Justice Alito delivered the opinion of the court, in which Chief Justice Roberts and Justices Thomas, Gorsuch, Kavanaugh, and Barrett joined. Section 2 of the Voting Rights Act of 1965, 52 U.S.C. Section 10301, was designed to enforce the Constitution, not collide with it. Unfortunately, lower courts have sometimes applied this court's Section 2 precedents in a way that forces states to engage in the very race-based discrimination that the Constitution forbids. This tension between Section 2 and the Constitution came to a head when Louisiana redrew its congressional districts after the 2020 census. In 2022, a federal judge in the Middle District of Louisiana held that the map adopted by the state legislature likely violated Section 2 because it did not include an additional majority black district. But when the state drew a new map that contained such a district, its new map was challenged as a racial gerrymander. A three-judge court in the Western District of Louisiana held that the new map violated the Equal Protection Clause, and the state appealed to this court. The parties originally briefed and argued this suit last term, and their arguments at the time highlighted problems in the existing body of Section 2 case law. One problem resulted from the rule that in racial gerrymandering cases, unlike other cases involving claims of racial discrimination, strict scrutiny is triggered only if race predominated in the state's decision-making process. In this suit, Louisiana adopted the challenged map and created the second majority black district because it quite reasonably anticipated that if it did not do so, the Middle District of Louisiana would order the use of a map with a differently configured second majority black district that would effectively oust an incumbent whom the legislature sought to protect. Under our existing case law, that situation posed the question whether race or politics was the state's predominant motivation. Another problem stemmed from the long unresolved question whether compliance with the Voting Rights Act provides a compelling reason that may justify the intentional use of race in drawing legislative districts. For over 30 years, we have assumed, for the sake of argument, that the answer is yes, and we have gone further and assumed that it is enough if a state has a strong basis in evidence for thinking that the Voting Rights Act requires race-based conduct. But allowing race to play any part in government decision-making represents a departure from the constitutional rule that applies in almost every other context. These and other problems convinced us that the time had come to resolve whether compliance with the Voting Rights Act can indeed provide a compelling reason for race-based districting. We now answer that question. Compliance with Section 2, as properly construed, can provide such a reason. Correctly understood, Section 2 does not impose liability at odds with the Constitution, and it should not have imposed liability on Louisiana for its 2022 map. Compliance with Section 2 thus could not justify the state's use of race-based redistricting here. The state's attempt to satisfy the Middle District's ruling, although understandable, was an unconstitutional racial gerrymander, and we therefore affirm the decision below. Part 1, Section A. Ratified in 1870, the 15th Amendment provides that the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. For many years afterward, however, states heavily suppressed the right of black citizens to vote. States employed a variety of notorious methods, including poll taxes, literacy tests, property qualifications, white primaries, and grandfather clauses in a blatant effort to suppress black voting. Even as late as the mid-1960s, black registration and voting rates in some states were appallingly low. In addition, states employed legislative redistricting schemes to prevent the election of black candidates and candidates that black voters preferred. Section 2 of the 15th Amendment authorizes Congress to enact appropriate legislation to enforce the amendment's protections, and in 1965, Congress invoked that power to enact the Voting Rights Act. The Act and its amendments in the 1970s specifically forbade some of the practices that had been used to suppress black voting, including literacy tests and poll taxes. We upheld many of these provisions in Katzenbach. Section 2 of the Voting Rights Act in its original form closely tracked the language of the amendment it was adopted to enforce. At that time, Section 2 stated simply that no voting qualification or prerequisite to voting or standard, practice, or procedure shall be imposed or applied by any state or political subdivision to deny or abridge the right of any citizen of the United States to vote on account of race or color. In Mobile v. Bolden, the court interpreted this language, and 4 justices concluded in a plurality opinion that facially neutral voting practices violate Section 2 only if motivated by a discriminatory purpose. Justice Stevens, who concurred in the judgment, proposed a different but similarly demanding standard. Indeed, in his view, a districting practice, even if motivated in part by race, would not violate Section 2 so long as it was supported by valid and articulable justifications. Bolden roused an avalanche of criticism both in the media and within the civil rights community. Critics argued that a focus on discriminatory intent rather than discriminatory effects would defeat worthy claims because of the difficulty of proving intentional discrimination. Members of Congress evidently shared these concerns. In 1982, shortly after Bolden, Congress sought to abrogate that decision by amending Section 2. The House bill was originally passed under a loose understanding that Section 2 would prohibit all discriminatory effects of voting practices and that intent would be irrelevant, but this version met stiff resistance in the Senate. Critics worried that an effects test would lead to mandatory racial proportionality in elections, a scenario regarded by many as intolerable. The House and Senate eventually compromised, and the final product included both an effects test in Section 2A and a robust disclaimer against proportionality in Section 2B. This latter provision also specifies what a plaintiff must establish to prove a Section 2 violation. The provision requires consideration of the totality of the circumstances in each case and demands proof that the political processes leading to nomination or election in the state or political subdivision are not equally open to participation by members of a protected class, in that its members have less opportunity than other members of the electorate to participate in the political process and to elect representatives of their choice. Congress took this language almost verbatim from Justice White's opinion for the court in White v. Register, which involved a vote dilution claim, i.e., a claim that a districting scheme impermissibly lessens the weight of the votes of minority voters. In White, the court affirmed a judgment that Texas had used 2 multi-member electoral districts invidiously to cancel out or minimize the voting strength of racial groups. According to White, a vote dilution plaintiff had to show that the political processes leading to nomination and election were not equally open to participation by the group in question, that its members had less opportunity than did other residents in the district to participate in the political processes and to elect legislators of their choice. The decision in White did not say anything one way or another about proof of discriminatory purpose or intent, but the court's rationale rested on evidence that gave rise to an obvious inference that the state had set out to prevent the election of candidates preferred by minority voters. The Texas districting scheme generally used single-member districts but employed multi-member districts in two parts of the state where single-member districts might have resulted in the election of minority candidates. The court observed that the use of multi-member districts is not necessarily or per se unconstitutional, but it recognized that such districts can be employed to achieve discriminatory ends. The court also cited strong evidence that the legislature had done so in the case at hand. Writing at a time when the Democratic Party was dominant in much of Texas, the court noted that a white-dominated organization which had effective control over candidate slating within that party had engaged in racial campaign tactics in white precincts to defeat candidates who had the overwhelming support of the black community, thereby effectively excluding the black community from participation in the Democratic primary selection process. The court likewise cited evidence that the legislature had invidiously excluded Mexican Americans from effective participation in political life, specifically in the election of representatives to the Texas House of Representatives. Thus, White presented a situation in which circumstantial evidence suggested very strongly that the state had created multi-member districts for the purpose of diluting minority votes. A few years later, when Congress looked for language that would abrogate Mobile v. Bolden's interpretation of Section 2, it selected terms that were nearly identical to language used in White. The accompanying report of the Senate Judiciary Committee explained that the amendment's purpose was to repudiate Bolden and establish a new vote dilution test based on White. Section B. This court first construed the amended version of Section 2 in Thornburg v. Jingles. Jingles concerned a challenge to North Carolina's multi-member districting scheme on the ground that it diluted the vote of black citizens. Jingles was decided at a time when this court often paid insufficient attention to the language of statutory provisions, and Justice Brennan's opinion for the court followed this pattern. Instead of analyzing what the statute said, the opinion simply quoted the text of amended Section 2 and then jumped right to the Senate Judiciary Committee report. Relying heavily on that report, the opinion set out 3 threshold requirements for proving a Section 2 vote dilution claim, plus a non-exhaustive list of factors to be considered in making a final decision as to whether the state had violated Section 2. To succeed in proving a Section 2 violation, Jingles taught, a plaintiff must make 4 showings. First, the plaintiff must show that the minority group in question is sufficiently large and geographically compact to constitute a majority in a reasonably configured district. A district is reasonably configured, we later explained, if it comports with traditional districting criteria, such as being contiguous and reasonably compact. Second, the minority group must be able to show that it is politically cohesive. Third, the minority must be able to demonstrate that the white majority votes sufficiently as a bloc to enable it to defeat the minority's preferred candidate. Finally, a plaintiff who demonstrates the 3 preconditions must also show, based on the totality of the circumstances, that the political process is not equally open to minority voters. Section C. In later cases, redistricting plans that states created to comply with the Voting Rights Act were themselves challenged as racial gerrymanders. The court approached such cases by building on the framework from other racial discrimination cases under the Equal Protection Clause. In those cases, if race played a role in a decision made by a government actor, strict scrutiny applied. Under this standard, the government needed to assert a compelling interest that justified its use of race, and if the analysis progressed beyond this point, the government had to show that its use of race was narrowly tailored to vindicate that interest. The court modified this framework for racial gerrymandering cases. Although any use of race in government decision-making generally triggers strict scrutiny, in gerrymandering cases, a challenger must show that race was the government's predominant consideration. In cases where race predominated, states would sometimes assert that compliance with the Voting Rights Act provided a compelling interest justifying the use of race, yet we never decided whether compliance with the act could constitute a compelling interest. Instead, we repeatedly assumed without deciding that the Voting Rights Act could constitute a compelling interest because in all those cases, the act actually did not demand the state's race-predominant districting. Thus, the states in those cases could not satisfy strict scrutiny regardless of whether compliance with the Voting Rights Act could provide a compelling interest. The first case in which the court explicitly made this assumption was Miller v. Johnson, which concerned a majority black district that was designed to satisfy the Justice Department's pre-clearance demands under Section 5 of the Voting Rights Act. Footnote 1. Such an assumption may have been implicit in Shaw v. Reno. Carrying on. The Miller Court first found that the legislature had subordinated traditional race-neutral districting principles, including but not limited to compactness, contiguity, and respect for political subdivisions or communities defined by actual shared interests, to racial considerations. For this reason, the court held race had predominated in the creation of the new district, and the state had to demonstrate that its districting legislation was narrowly tailored to achieve a compelling interest. The court declined to address whether or not in some cases compliance with the Voting Rights Act standing alone could provide a compelling interest independent of any interest in remedying past discrimination. Instead, the court explained that the challenged district was not reasonably necessary under a constitutional reading and application of the Voting Rights Act, so the state's goal of complying with the act could not supply a compelling interest. We repeated much the same analysis in Shaw v. Hunt, applying strict scrutiny to a redistricting plan that a state crafted to comply with both Section 2 and Section 5 of the Voting Rights Act. Once again, we did not reach the question expressly left open in Miller, whether the Voting Rights Act could itself provide a compelling interest to justify race-predominant districting. After assuming arguendo for the purpose of resolving this suit that compliance with Section 2 could be a compelling interest, we held that the plan failed strict scrutiny because it was not reasonably required under a constitutional reading and application of the Voting Rights Act. Likewise, in Alabama Legislative Black Caucus v. Alabama, we applied strict scrutiny to a race-predominant districting plan that the state had created for two purposes. First, to come close to a one-person, one-vote ideal, and second, to ensure compliance with Section 5 of the Voting Rights Act. We held that, even if the Voting Rights Act could provide a compelling interest, the map did not satisfy strict scrutiny because it was not required by the Act. Once again, we left open whether compliance with the Act remained a compelling interest. In Cooper, we continued our long-standing assumption that complying with the VRA is a compelling interest. Again, we did not need to resolve this question because a constitutional reading and application of the Act did not require the district at issue. And again, in Wisconsin legislature, we once more assumed that complying with the Voting Rights Act is a compelling interest. But because the Wisconsin Supreme Court had not properly analyzed whether the act required the map at issue, we remanded for the court to undertake a full strict scrutiny analysis. This was the legal framework in place when the lawsuits involving Louisiana's congressional districts were filed and litigated in the lower courts. Part 2. As noted earlier, the underlying litigation in this suit resulted from Louisiana's response to the population changes disclosed by the 2020 census. The subsequent reapportionment of the House seats among the states left Louisiana with the same number of seats, 6, that it had previously been allocated, but due to shifts in population, the state needed to recalibrate its districts. Figure 1 shows Louisiana's map from 2013 to 2022. For obvious reasons, I'm not going to attempt to describe it, so if you would like to see it, there is a link to the opinion in the description of this episode. In 2022, Louisiana enacted a new map, HB 1, that closely resembled its immediate predecessor. Figure 2 shows HB 1 enacted in 2022. Again, if you would like to see it, link in the description. HB 1, like its predecessor, included only one district in which black voters were a majority of the voting age population. In the above maps, it is the bat-shaped District 2 that includes much of New Orleans, blue in Figure 1 and yellow in Figure 2. As soon as HB 1 was enacted, lawsuits were filed in the Middle District of Louisiana asserting that the map violated the Voting Rights Act by packing large numbers of black voters into a single majority black congressional district and cracking the remaining black voters among the other 5 districts. After the suit was filed, the Robinson Court issued a lengthy opinion concluding that HB 1 likely violated the Voting Rights Act by failing to include a second majority black district. The court thus entered a preliminary injunction requiring Louisiana to implement a new map before the 2022 election, which was less than 6 months away. Louisiana objected to the decision and promptly appealed, but because of circumstances outside the state's control, its appeal ended up in limbo. This court granted certiorari before judgment and held the case pending a decision in Allen. Nearly a year later, after deciding Allen, this court dismissed the petition as improvidently granted and remanded the case to the Fifth Circuit to consider Louisiana's appeal in the ordinary course. By that time, the 2022 election had passed and the urgency that had justified the preliminary injunction was no longer present. In a tentatively worded opinion, the Fifth Circuit held that the Robinson District Court's decision was valid when it was issued, but that the preliminary injunction was no longer needed. In the absence of urgency, the Fifth Circuit remanded the case to the District Court with instructions to give Louisiana time to draw a new map. If Louisiana failed to do so, the Fifth Circuit suggested the District Court could proceed with a trial on the merits and, if needed, remedial proceedings. After the Fifth Circuit's remand, Louisiana did not have many options. In the Robinson decision, the District Court held that the plaintiffs were likely to prevail on their claim that the Voting Rights Act demanded the creation of a second majority black district. So if Louisiana refused to adopt a new map, the District Court would likely draw one and mandate its use. Wishing to avoid that outcome, Louisiana decided to draw its own map. After a deliberative process, Louisiana enacted the map at issue in this suit, SB 8. Figure 3 shows SB 8. Again, link in the description if you would like to view it. SB 8 retains the original majority-minority district from HB 1 above in yellow. It then adds an additional majority-minority district, District 6, above in green. To attain a majority black voting age population, District 6 connects black populations from Baton Rouge and Lafayette in the south-central region of the state, with the black population in Shreveport in the far northwest of the state. SB 8 differed from the illustrative maps shown below, on which the District Court relied in Robinson. Figure 4 shows the Robinson Court's illustrative maps. There are 6 of them. Again, link in the description if you would like to view them. These illustrative maps also include a second majority-minority district, but one with very different boundaries, shown in blue in the top 4 maps and green in the bottom 2 maps. This district connects largely urban black communities in Baton Rouge and Lafayette with more rural black communities in the northeast corner of the state. By contrast, SB 8 District 6 connects Baton Rouge and Lafayette black populations with the distant black population in Shreveport in the northwest. Louisiana adopted this scheme rather than the one used in the Robinson illustrative maps because it protects the Republican incumbents the state considered most important: Speaker of the House Mike Johnson, House Majority Leader Steve Scalise, and Appropriations Committee member Julia Letlow. Not long after SB 8 was enacted, another lawsuit was filed, this time in the Western District of Louisiana. A group of plaintiffs, the Callais plaintiffs, asserted that SB 8 and specifically District 6 was a racial gerrymander that violated the Equal Protection Clause. The plaintiffs from Robinson intervened in the litigation, seeking to defend Louisiana's decision to draw a second majority-minority district. Because the Callais plaintiffs challenged the constitutionality of the apportionment of congressional districts, a district court of 3 judges was convened to hear the suit. The court held a 3-day preliminary injunction hearing, which was consolidated with a trial on the merits. Observing that SB 8's second majority-minority district stretches some 250 miles from Shreveport in the northwest corner of the state to Baton Rouge in southeast Louisiana, slicing through metropolitan areas to scoop up pockets of predominantly black populations from Shreveport, Alexandria, Lafayette, and Baton Rouge, the court concluded that the map affected a racial gerrymander that violates the Equal Protection Clause. Judge Stewart of the Fifth Circuit dissented. The state of Louisiana and the Robinson interveners appealed the decision directly to this court, and the court noted probable jurisdiction. After an initial round of briefing and argument last term, the court restored these cases to the calendar for re-argument this term. We ordered supplemental briefing on the following question: whether the state's intentional creation of a second majority-minority congressional district violates the 14th or 15th Amendments to the U.S. Constitution. And because the state's intentional creation of a second majority-minority district had been prompted by an order suggesting that such a district was required by the Voting Rights Act, Our question necessarily implicated the correctness of our long-standing assumption that compliance with the Voting Rights Act may justify what the Constitution generally condemns: the use of race as a basis for government action. This question was pending in several lower court cases, but in light of the potential impact of those cases on upcoming elections, we concluded that resolution of the question in this suit was appropriate. Part 3, Section A. In considering whether the Constitution permits the intentional use of race to comply with the Voting Rights Act, we start with the general rule that the Constitution almost never permits the federal government or a state to discriminate on the basis of race. Such discrimination triggers strict scrutiny, and our precedents have identified only two compelling interests that can satisfy that standard. One compelling interest, not relevant here, is avoiding imminent and serious risks to human safety in prisons, such as a race riot. The only other compelling interest we have found is remediating specific identified instances of past discrimination that violated the Constitution or a statute. To rise to the level of a compelling state interest, an effort to remediate past discrimination must identify two conditions. First, the discrimination must be identified discrimination. In other words, the state or federal government must identify the specific instances of past discrimination that it aims to remediate, and, in light of that specification, must determine the precise scope of the injury it seeks to remedy. The states and federal government have no compelling interest in generally remediating past discrimination in a particular industry or region or the effects of societal discrimination. Second, after identifying the specific instance of discrimination, the institution that makes the racial distinction must have a strong basis in evidence to conclude that its remedial action is necessary. Our acceptance of race-based state action has been rare for a reason. Distinctions between citizens solely because of their ancestry are, by their very nature, odious to a free people whose institutions are founded upon the doctrine of equality. And in redistricting, where the state assumes from a group of voters' race that they think alike, share the same political interests, and will prefer the same candidates at the polls, it engages in racial stereotyping at odds with equal protection mandates. The question before us now is whether compliance with the Voting Rights Act should be added to our very short list of compelling interests that can justify racial discrimination. To answer that question, we must understand exactly what Section 2 of the Voting Rights Act demands with respect to the drawing of legislative districts. We therefore turn to the text of that provision. Section B, subsection 1. As amended in 1982, Section 2 states, quote, A. No voting qualification or prerequisite to voting or standard, practice, or procedure shall be imposed or applied by any state or political subdivision in a manner which results in a denial or abridgment of the right of any citizen of the United States to vote on account of race or color, as provided in subsection B. B. A violation of subsection A is established if, based on the totality of the circumstances, it is shown that the political processes leading to nomination or election in the state or political subdivision are not equally open to participation by members of a class of citizens protected by subsection A, in that its members have less opportunity than other members of the electorate to participate in the political process and to elect representatives of their choice. The extent to which members of a protected class have been elected to office in the state or political subdivision is one circumstance which may be considered, provided that nothing in this section establishes a right to have members of a protected class elected in numbers equal to the proportion of the population. End quote. 52 U.S.C. Section 10301. This is not the easiest language to parse, and we will therefore break it down in steps. Beginning with subsection A, we take as a given that a legislative districting map may constitute a standard, practice, or procedure. If that were not so, there would have been no statutory basis for any of our Section 2 vote dilution cases. Therefore, subsection A means that a districting map may run afoul of Section 2 if it results in a denial or abridgment of the right to vote on account of race or color. With that established, subsection B explains when such a denial or abridgment occurs: when the political processes leading to nomination or election are not equally open to participation by members of a racial group of voters in that they have less opportunity than other members of the electorate to elect representatives of their choice. In this complicated verbal formulation, the key concept for present purposes is less opportunity than other members of the electorate to elect representatives of their choice. This language sets a baseline against which to assess the opportunity of minority voters, the opportunity that other members of the electorate have to elect their preferred candidates. To understand this baseline, we must nail down the meaning of three terms: less opportunity, other members of the electorate, and elect. In isolation, opportunity could refer to either a desired outcome or a chance to achieve that outcome. As used in Section 2, however, opportunity must mean a chance to achieve a desired result, because the Voting Rights Act does not guarantee equal outcomes. Accordingly, less opportunity must mean a lesser chance. In ordinary usage, less opportunity often takes such a meaning. One might say, for example, that men under 6 feet tall have less opportunity to play in the NBA than those who stand at least 6 feet 7 inches, the current median. The next term, other members of the electorate, specifies the comparator to be used in determining whether the group protected by subsection A has suffered or is threatened with suffering less opportunity to elect representatives of their choice. In conceptualizing the members of this comparator group, we may think of a randomly selected member of the electorate who has particular voting preferences, or we may think of a randomly selected group of voters who share certain voting preferences. These voting preferences may be based on a candidate's party affiliation, ideology, stance on a particular policy issue, personal charisma, or some other characteristic or set of characteristics. But whatever they are, the situation of these randomly selected voters must be compared with that of minority voters alleging to have suffered vote dilution. This brings us to the final term, to elect. As used in Section 2b, this term must refer to the achievement of electoral victory by casting a ballot. Putting all these terms together, the baseline is the chance enjoyed by non-minority voters to secure the election of their preferred candidates. What, then, is the chance that any given non-minority voter or group of non-minority voters has to secure the election of a preferred candidate? The answer to this question depends on the voting preferences of other voters in the district. For example, in a district where most voters prefer Democratic candidates, a Republican voter in that district will have a low chance of securing the election of his or her preferred candidate. But that chance would be substantially higher if the district were instead filled with voters who prefer Republican candidates. The roster of voters who end up in a given district depends in turn on the districting criteria used by the state in drawing a legislative map. If a districting map is produced by a computer, as is generally the case today, we may think of all the parameters in the algorithm that the mapmaker uses. One necessary parameter would be the number of districts required by law, and another would have to be a range of inter-district population variations that is small enough to comply with the one-person, one-vote requirement. The algorithm might then go on to lay out and assign priorities to whatever additional permissible criteria the legislature chooses to use. For example, the legislature might want to minimize changes in the prior map, avoid districts with discontiguous territory, and avoid splitting counties or municipalities. It might impose a certain standard of compactness, aim to protect some or all incumbents, or promote the prospects of a particular political party. When this algorithm is used, the map it produces may place a particular voter or group of voters in a district in which a majority generally agrees, generally disagrees, or only sometimes agrees with their voting preferences. But in any event, the opportunity of these members of the electorate to contribute their votes to a winning cause is whatever opportunity results from the application of the state's combination of permissible criteria. That is what our randomly selected individual voter and group of voters can expect regarding their opportunity to elect a preferred candidate, and under Section 2, a minority voter is entitled to nothing less and nothing more. Subsection 2. Not only is this the best reading of the statutory text, but it also ensures that Section 2 of the Voting Rights Act does not exceed Congress's authority under Section 2 of the 15th Amendment. That provision confers the power to enforce the amendment by appropriate legislation. Thus, to lie within Congress's authority, Section 2 of the Voting Rights Act must effectuate by appropriate measures the constitutional prohibition in Section 1 of the 15th Amendment. Our 14th and 15th Amendment jurisprudence delineates what constitutes appropriate legislation in the sense relevant here. In legislation enforcing these amendments, there must be a congruence and proportionality between the injury to be prevented or remedied and the means adopted to that end. As the court has long held, the 15th Amendment bars only state action motivated by a discriminatory purpose. So a law that seeks to enforce the 15th Amendment by prohibiting mere disparate impact would fail to enforce a right that the amendment secures. That is never appropriate because Congress cannot enforce a constitutional right by changing what the right is. For this reason, the focus of Section 2 must be enforcement of the 15th Amendment's prohibition on intentional racial discrimination. When Section 2 is properly interpreted in the way we have outlined, it is sufficiently congruent with and proportional to the amendment's prohibition. While that interpretation does not demand a finding of intentional discrimination, it imposes liability only when the circumstances give rise to a strong inference that intentional discrimination occurred. Suppose, for example, that the application of a state's districting algorithm yields numerous maps with districts in which the members of a minority group constitute a majority, and suppose that the state cannot provide a legitimate reason for rejecting all those maps and eliminating all majority-minority districts. In such a situation, the inference of racial motivation is strong, and Section 2 of the 15th Amendment permits the imposition of liability without demanding that the courts engage in the fraught enterprise of attempting to determine whether the state legislature as an institution, as opposed to certain individual members or the state's hired mapmaker, was motivated by race. Only when understood this way does Section 2 of the Voting Rights Act properly fit within Congress's 15th Amendment enforcement power. By contrast, interpreting Section 2 of the Voting Rights Act to outlaw a map solely because it fails to provide a sufficient number of majority-minority districts would create a right that the amendment does not protect. And such an interpretation would run headlong into the Act's express disclaimer against racial proportionality. Properly understood, Section 2 thus does not intrude on states' prerogative to draw districts based on non-racial factors. Redistricting constitutes a traditional domain of state legislative authority. The Constitution imposes some important restrictions on the state's exercise of this power, but they are otherwise free to draw districts as they please. We have held that they may use traditional districting factors such as compactness, contiguity, maintaining the integrity of political subdivisions, preserving the core of existing districts, and protecting incumbents. Nothing in the Constitution requires states to heed these criteria, of course, and the desirability of some of these criteria might be disputed. But because they are not forbidden by the Constitution, it is up to each state to decide what weight, if any, they warrant. The same is true with respect to the drawing of districts to achieve partisan advantage. Disapproval of partisan gerrymandering dates back to the founding. But partisan gerrymandering claims are not justiciable in federal court. Federal judges have no license to reallocate political power between the two major political parties, with no plausible grant of authority in the Constitution and no legal standards to limit and direct their decisions. Thus, in considering the constitutionality of a districting scheme, courts must treat partisan advantage like any other race-neutral aim, a constitutionally permissible criterion that states may rely on as desired. For this reason, as we have repeatedly made clear, when a state defends a districting scheme on the ground that it was drawn for partisan purposes, plaintiffs have a special burden to overcome. To prevail, the plaintiff must disentangle race from politics by proving that the former drove a district's lines. That means, among other things, ruling out the competing explanation that political considerations dominated the legislature's redistricting efforts. If either politics or race could explain a district's contours, the plaintiff has not cleared its bar. A plaintiff may carry its disentanglement burden by offering an alternative map that achieves all the state's objectives, including partisan advantage and any of the state's other political goals, at least as well as the state's map. Today, Section 2 litigants almost always have the wherewithal to proffer such a map if there is one to be found. But if a Section 2 plaintiff cannot disentangle race from the state's race-neutral considerations, including politics, then Section 2 cannot impose liability. In short, Section 2 imposes liability only when the evidence supports a strong inference that the state intentionally drew its districts to afford minority voters less opportunity because of their race. Not only does this interpretation follow from the plain text of Section 2, but it is consistent with the limited authority that the 15th Amendment confers. Section C. This interpretation of Section 2 does not require abandonment of the Jingles framework. We need only update the framework so it aligns with the statutory text and reflects important developments since we decided Jingles 40 years ago. 4 historical developments are of particular note. First, vast social change has occurred throughout the country and particularly in the South where many Section 2 suits arise. As this court has recognized, things have changed dramatically in the decades since the passage of the Voting Rights Act. At the time of the Act's passage, the nation had faced nearly a century of entrenched racial discrimination in voting, an insidious and pervasive evil which had been perpetuated in certain parts of our country through unremitting and ingenious defiance of the Constitution. But the Voting Rights Act led to great strides in ensuing decades. Voting tests were abolished, disparities in voter registration and turnout due to race were erased, and African Americans attained political office in record numbers. By 2004, the racial gap in voter registration and turnout had largely disappeared, with minorities registering and voting at levels that sometimes surpassed the majority. Black voters now participate in elections at similar rates as the rest of the electorate, even turning out at higher rates than white voters in 2 of the 5 most recent presidential elections nationwide and in Louisiana. Second, a full-blown 2-party system has emerged in the states where Section 2 suits are most common. Jingles arose in the context of a one-party system in which black and white voters had starkly different voting patterns despite their affiliation with the same party. In the area involved in Jingles, an overwhelming majority of white voters did not vote for any black candidate in the Democratic Party primary elections, which for all practical purposes selected the candidates who would ultimately obtain office. And in general elections, white voters, in heavily Democratic areas, often ranked black candidates last among Democrats. Such intra-party disparities showed that black voters had less opportunity to elect their preferred candidate because of their race, not because of their partisan affiliation. When the vast majority of voters, regardless of race, favors the same political party, a map that is disadvantageous for members of one racial group cannot be explained on the ground that it was drawn to favor a particular political party. But in a state where both parties have substantial support and where race is often correlated with party preference, a litigant can easily exploit Section 2 for partisan purposes by repackaging a partisan gerrymandering claim as a racial gerrymandering claim. That brings us to the third significant post-Jingles development, this court's decision in Rucho. In that decision, we held that claims of partisan gerrymandering are not justiciable in federal court. The upshot of Rucho was that as far as federal law is concerned, a state legislature may use partisan advantage as a factor in redistricting. And litigants cannot circumvent that rule by dressing their political gerrymandering claims in racial garb. Imposing liability based on the racial effects of a political gerrymander in a jurisdiction in which race and partisan preference are very closely correlated would, if accepted, provide a convenient way for future litigants and lower courts to sidestep our holding in Rucho that partisan gerrymandering claims are not justiciable in federal court. Instead of claiming that a state impermissibly set a target Republican-Democrat breakdown, a plaintiff could simply reverse engineer the partisan data into racial data and argue that the state impermissibly set a particular racial target. Our decisions cannot be evaded with such ease. The fourth significant development since Jingles is increased use and capabilities of computers in drawing districts and creating illustrative maps. With modern computer technology at the ready, Section 2 plaintiffs invariably invoke the assistance of experts who can generate thousands or even millions of maps. Computer algorithms can easily control for partisan preferences and other redistricting factors such as compactness and county splits. With the advent of such technology, if it is possible to identify an alternative map that fully achieves all the state's legitimate goals while producing greater racial balance, then a Section 2 plaintiff can easily do so. In light of these significant developments, it is appropriate to update the Jingles framework and realign it with the text of Section 2 and constitutional principles. 1. First Jingles precondition. The first Jingles precondition is that a community of minority voters must be sufficiently numerous and compact to constitute a majority in a reasonably configured district. To satisfy this precondition, many Section 2 plaintiffs have simply provided illustrative maps with their desired number of majority-minority districts. Such maps, however, are not alone sufficient. They prove only that the state could create an additional majority-minority district, not that the state's failure to do so violated Section 2 of the Voting Rights Act. To make the latter showing, plaintiffs' illustrative maps must satisfy two conditions. First, in drawing illustrative maps, plaintiffs cannot use race as a districting criterion. If a plaintiff can produce an additional majority-minority district only by using race, a process that would be unconstitutional if a state engaged in such map-making, that illustrative map sheds no light on whether the state acted unconstitutionally by not adopting such a map. Thus, an illustrative map in which race was used has no value in proving a Section 2 plaintiff's case. Second, illustrative maps must meet all the state's legitimate districting objectives, including traditional districting criteria and the state's specified political goals. If the state's aims in drawing a map include a target partisan distribution of voters, a specific margin of victory for certain incumbents, or any other goal not prohibited by the Constitution, the plaintiff's illustrative maps must achieve these goals just as well. If not, the plaintiffs would fail to demonstrate that the state's chosen map was driven by racial considerations rather than permissible aims. Only by meeting all the state's legitimate objectives can the illustrative maps help to disentangle race from politics and other constitutionally permissible considerations. 2. Second and third Jingles preconditions. To satisfy the second and third preconditions, politically cohesive voting by the minority and racial bloc voting by the majority, the plaintiffs must provide an analysis that controls for party affiliation. In other words, they must show that voters engage in racial bloc voting that cannot be explained by partisan affiliation. That is, once again, critical for disentangling race and politics. The facts of Jingles afford a good example of how a Section 2 plaintiff can properly meet these preconditions. There, as discussed, black and white voters had dramatically different voting patterns within the Democratic Party. This type of intra-party racial bloc voting pattern helps to demonstrate that the minority plaintiffs have less opportunity than their majority counterparts because of race, not just because of partisan affiliation. By contrast, simply pointing to inter-party racial polarization proves nothing because a jurisdiction may engage in constitutional political gerrymandering even if it so happens that the most loyal Democrats happen to be black Democrats, and even if the state were conscious of that fact. 3. Totality of circumstances. Last, the totality of circumstances inquiry must focus on evidence that has more than a remote bearing on what the 15th Amendment prohibits, present-day intentional racial discrimination regarding voting. Discrimination that occurred some time ago, as well as present-day disparities that are characterized as the ongoing effects of societal discrimination, are entitled to much less weight. Far more germane are current data and current political conditions that shed light on current intentional discrimination. In large part because of the Voting Rights Act, our nation has made great strides in eliminating racial discrimination in voting. And if, as a result of this progress, it is hard to find pertinent evidence relating to intentional present-day voting discrimination, that is cause for celebration. Section D. Nothing in Allen dictates a result that differs from the one we reach today. The decision in that case was based on the state of Alabama's specific argument that its race-neutral benchmark was necessary in any redistricting case. Alabama argued that deriving this benchmark, the median or average number of majority-minority districts in a race-blind multi-million map set, required computer simulations that are technically complicated, expensive to produce, and available to only a small cadre of university researchers that have the resources and expertise to run them. Nonetheless, the state contended that its race-neutral benchmark was the only plausible test to ensure that Section 2 stays within the constitutional guardrails. We rejected that single-minded view. Allen, in short, was about whether Alabama's novel evidentiary standard required a change to our existing Section 2 precedent. It did not. Allen did not address the central issue here. We had no occasion in Allen to confront the presumption that compliance with Section 2 may serve as a compelling interest for a state to satisfy strict scrutiny. Indeed, Allen did not discuss the 14th Amendment at all. Here, by contrast, it is the linchpin of this suit. Footnote 2. The dissent claims that the 14th Amendment is irrelevant to our analysis, but the dissent appears to forget, or at least tries to lead readers to forget, that the decision before us is based on the 14th Amendment. The plaintiffs claimed, and the court below held, that the map enacted by the state legislature in SB 8 impermissibly discriminated on the basis of race and thus violated the plaintiffs' rights under the 14th Amendment's Equal Protection Clause. Carrying on. In addition, our decision in Allen did not reach two pivotal issues that we now squarely address. First, we left open whether race-based redistricting under Section 2, even if permissible when the Voting Rights Act was enacted in 1982, could extend indefinitely into the future despite significant changes in relevant conditions. Second, because the state in Allen did not cite partisan goals in defending its map, we did not address whether Section 2 plaintiffs must disentangle race from politics in proving their case. Indeed, this is our first occasion to address the implications of Rucho in a vote dilution case. Failing to account for political considerations in redistricting, as explained above, can allow plaintiffs to undo a state's legitimate non-racial decisions under the banner of Section 2. In light of our answers to these questions left open in Allen, we now update the Jingles test to ensure a constitutional reading and application of Section 2. Part 4. Under the updated Jingles framework, the facts of this suit easily require affirmance. Louisiana's enactment of SB 8 triggered strict scrutiny because the state's underlying goal was racial. The state never hid the ball. It configured District 6 to achieve a black voting age population over 50% because it knew that if it failed to do so, the Robinson court would very likely find its map unlawful and order the use of something like the Robinson plaintiffs' illustrative maps, which would have imperiled one of the influential incumbents the legislature sought to protect. The state's intentional compliance with the court's demands constituted an express acknowledgement that race played a role in the drawing of district lines. Louisiana therefore had to satisfy the extraordinarily onerous standard of proving that its use of race was narrowly tailored to further a compelling governmental interest. No compelling interest justifies SB 8. Section 2 does not provide a compelling interest because the state did not need to create a new majority-minority district to comply with the act. That is because at every step of the Jingles framework, the Robinson plaintiffs failed to prove their Section 2 case. On the first Jingles precondition, the Robinson plaintiffs did not meet their burden because they did not provide an illustrative map that met all the state's non-racial goals. The most obvious deficit in the plaintiffs' illustrative maps was the failure to meet the state's political goals, including incumbency protection. The plaintiffs' preferred map would have placed Representative Letlow in a majority Democrat district and thus effectively ensured her exit from Congress. The Robinson court erroneously concluded that the plaintiffs' illustrative maps protected incumbents because the map left all 6 representatives in the district where they currently live and could avoid incumbent pairing. That observation missed the point. An incumbent is not protected if he or she will lose re-election. And because the plaintiffs' illustrative maps failed to protect all the incumbents that the state sought to shield, the plaintiffs did not meet their burden on this precondition. Nor did the plaintiffs meet their burden on the second and third Jingles preconditions. To show racially polarized voting, the Robinson plaintiffs offered evidence that black and white voters consistently supported different candidates, but their analysis did not control for partisan preferences. Even if the Robinson plaintiffs had met their burden on the Jingles preconditions, they still would have failed to show an objective likelihood of intentional discrimination based on the totality of circumstances. The Robinson court went through the 9 Senate report factors, but none of the evidence it cited showed even a plausible likelihood of intentional discrimination by the state. Much of the cited evidence, such as the low number of black Louisianans who have been elected to Congress in recent decades, failed to disentangle race from politics. Indeed, the court observed that black voters have been aligned with the Democratic Party for decades and that issues discussed by that party appealed to black voters. Those observations should have undercut, not strengthened, any showing of intentional racial discrimination because race and politics are so intertwined. The Robinson Court also relied on the sordid history of intentional discrimination by Louisianan officials in the decades before the Voting Rights Act's passage. And it cast aside as irrelevant the lack of evidence that black voters had faced intentional discrimination in recent years. That analysis had its priorities backwards. The 15th Amendment, which the Voting Rights Act enforces, is not designed to punish for the past, but works to ensure better futures. The focus of Section 2 must therefore be on current conditions, not on decades-old data relevant to decades-old problems. And none of the historical evidence presented by the plaintiffs came close to showing an objective likelihood that the state's challenged map was the result of intentional racial discrimination. In sum, because the Voting Rights Act did not require Louisiana to create an additional majority-minority district, no compelling interest justified the state's use of race in creating SB 8. That map is an unconstitutional gerrymander, and its use would violate the plaintiff's constitutional rights. Part 5. The dissent's arguments are fully addressed in the prior sections of this opinion, but in closing, we emphasize 3 points. First, the dissent states over and over again that our decision requires the Section 2 plaintiff to prove discriminatory intent. What must be shown is exactly what the 1982 amendment of Section 2 called for. A Section 2 plaintiff in a vote dilution case must show that a districting scheme denies members of a racial group the same opportunity as other voters to elect the candidates they prefer. When that is shown, the circumstances are comparable to those in White, the decision from which the new language added by Congress in 1982 was drawn. That is, the circumstances must give rise to a strong inference of racial discrimination. Second, contrary to the dissent's assertion, we have not overruled Allen. As is our general practice, the Allen court adjudicated the case based on the party's arguments, and in that case, the state did not defend its map on the ground that it was drawn to achieve a political objective. Here, the state has been forthright from the beginning that its aim was to protect the state's most prominent Republican House members. One may lament partisan gerrymandering, but for the reasons explained in Rucho, partisan gerrymandering claims are not justiciable in federal court. And in a racial gerrymandering case like the one before us, race and politics must be disentangled, as even the author of the dissent has acknowledged. That is true regardless whether the case is brought pursuant to the 14th Amendment or the VRA, since Section 2 of the VRA requires evidence giving rise to a strong inference of intentional discrimination. If race and politics are not disentangled and a Section 2 claim is cynically used as a tool for advancing a partisan end, the VRA's noble goal will be perverted. Third, while the dissent wraps itself in the mantle of stare decisis, the dissent is unabashedly at war with key precedents. Respect for precedent cannot be a one-way street. The judgment of the district court is affirmed, and these cases are remanded for proceedings consistent with this opinion. It is so ordered. Justice Thomas, with whom Justice Gorsuch joins, concurring. I join the court's opinion in full. This court should never have interpreted Section 2 of the Voting Rights Act of 1965 to effectively give racial groups an entitlement to roughly proportional representation. By doing so, the court led legislatures and courts to systematically divide the country into electoral districts on racial lines. Blacks were drawn into black districts and given black representatives, Hispanics were drawn into Hispanic districts and given Hispanic representatives, and so on. That interpretation rendered Section 2 repugnant to any nation that strives for the ideal of a colorblind constitution. Today's decision should largely put an end to this disastrous misadventure in voting rights jurisprudence. As I explained more than 30 years ago, I would go further and hold that Section 2 of the Voting Rights Act does not regulate districting at all. The relevant text prohibits states from imposing or applying a voting qualification, prerequisite to voting, or standard practice or procedure in a manner that results in a denial or abridgment of the right to vote based on race. How states draw district lines does not fall within any of those three categories. The words in Section 2 instead reach only enactments that regulate citizens' access to the ballot or the processes for counting a ballot. They do not include a state's choice of one districting scheme over another. Therefore, no Section 2 challenge to districting should ever succeed. Justice Kagan, with whom Justice Sotomayor and Justice Jackson join, dissenting. Consider the story of a hypothetical congressional district in a hypothetical state, subjected to a redistricting scheme. The example is admittedly stylized, but in its essence simulates the dispute before us and clarifies the immense issues at stake. The district, let's say, is a single county in the shape of a near-perfect circle, sitting in the middle of a rectangular state. The state is one with a long history of virulent racial discrimination, and its many effects, including in residential segregation and political division, remain significant even today. The population of the Circle District is 90% black. The rest of the state, divided into 5 surrounding districts, is 90% white. And voting throughout all those districts is racially polarized. Black residents vote heavily for Democratic candidates, while white residents vote heavily for Republicans. The Circle District thus enables the state's black community to elect a representative of its choice whom no neighboring community would put in office. But that arrangement, in this not-so-hypothetical, is not to last. The state legislature decides to eliminate the Circle District, slicing it into 6 pie pieces and allocating 1 each to 6 new, still solidly white congressional districts. The state's black voters are now widely dispersed and, unlike the state's white voters, lack any ability to elect a representative of their choice. Election after election, black citizens' votes are, by every practical measure, wasted. That is a racial vote dilution in its most classic form. A minority community that is cohesive in its geography and politics alike, and that faces continued adversity from racial discrimination, is split. Cracked is the usual term, so that it loses all its electoral influence. Members of the racial minority can still go to the polls and cast a ballot, but given the state's racially polarized voting, they cannot hope, in the way the state's white citizens can, to elect a person whom they think will well represent their interests. Their votes matter less than others do. They translate into less political voice. Or, as this court put it recently, the cracking makes a minority vote unequal to a vote by a non-minority voter. And because that is so, Congress in the Voting Rights Act made the practice illegal. Section 2 of that act guarantees that members of every racial group have an equal opportunity to elect representatives of their choice. That promise arose from a far too prominent part of this nation's history. Even after the 15th Amendment banned racial discrimination in voting, state officials routinely deprived African Americans of their voting rights. Through a seemingly boundless array of mechanisms, most of them facially race-neutral and among them the drawing of district lines, states either prevented black citizens from casting ballots or ensured that their votes would count for next to nothing. The Voting Rights Act was meant as the corrective, and when this court construed it too narrowly, insisting that a person suing under Section 2 had to prove discriminatory intent, Congress amended the law so that it turned solely on discriminatory effects. Under that revised version, a person has a good Section 2 claim if the challenged state action in the totality of circumstances results in an electoral system not equally open to members of his racial group, meaning a system giving those citizens less opportunity to participate in the political process and to elect representatives of their choice. And for 40 years now, this court has recognized that language to encompass districting decisions that, in the way illustrated above, result in vote dilution, the minimizing of minority voters' ability to elect their preferred candidates. But no longer. Under the court's new view of Section 2, a state can, without legal consequence, systematically dilute minority citizens' voting power. Of course, the majority does not announce today's holding that way. Its opinion is understated, even antiseptic. The majority claims only to be updating our Section 2 law as though through a few technical tweaks, but in fact, those updates eviscerate the law so that it will not remedy even the classic example of vote dilution given above. Without a basis in Section 2's text or the Constitution, the majority formulates new proof requirements for plaintiffs alleging vote dilution. Those demands, meant to disentangle race from politics, leverage two features of modern political life: that racial identity and party preference are often linked, and that politicians have free rein to adopt partisan gerrymanders. The first fact say that in a given area, black voters mainly support Democrats and white voters Republicans, was viewed before today as practically an element of a vote dilution claim, because it indicates that a minority group is politically cohesive enough to elect a preferred representative but will be outvoted by the majority bloc. The second fact, the result of a prior mistake by this court, is something every day to regret, not to use as an excuse for stripping minority citizens of their voting rights. But under the majority's new test, when those two facts coexist, which is almost everywhere Section 2 still has purchase, a plaintiff cannot prevail by showing that a redistricting resulted in the dilution of minority voting power. Rather, a plaintiff will have to show, contrary to Section 2's clear text and design, that the legislators were motivated by discriminatory purpose, and that, as Section 2's drafters knew, is well nigh impossible. Today's ruling is part of a set. For over a decade, this court has had its sights set on the Voting Rights Act. In 2013, the court made a nullity of Section 5, the provision of the act enabling the Department of Justice to review and block new voting rules, including redistrictings, in jurisdictions with a history of voter suppression. See Shelby County v. Holder. Congress had recently, and after lengthy study, reauthorized that preclearance mechanism. It found the scheme still essential to counter the protean techniques states can use to prevent minorities from exercising their fair share of political influence. But this court thought it knew better. Things have changed dramatically, the court explained, ignoring that whether things had changed dramatically enough to make the law dispensable was a question better left to its democratically accountable authors. Not surprisingly, a flood of discriminatory voting laws followed, and now only Section 2 stood in the gap. In 2021, the court did half what was needed to raise that Section 2. See Brnovich v. Democratic National Committee. Section 2 prohibits not only vote-diluting districting plans, but also discriminatory burdens on the casting of ballots. In a suit involving the latter type of law, the court invented a new legal standard making Section 2 useless on the theory that the statute as written was too radical. Since the court ruled, not a single Section 2 suit has successfully challenged such a restriction on voting, however discriminatory in operation. And finally, today, the last piece, Section 2 as applied to redistricting. The last, and surely the hardest, for just 3 terms ago, the court upheld a vote dilution challenge to a districting map in a case much like this one, preserving Section 2 as a tool to prevent racially discriminatory redistricting. We declined to adopt, the court said then, an interpretation of Section 2 that would revise and reformulate our Section 2 jurisprudence of nearly 40 years. Nothing has changed in the 3 years since. Yet today, the majority does revise and reformulate and destroy. It avails itself again of the tools used before to dismantle the act. Untenable readings of statutory text, made up and impossible to meet evidentiary requirements, disregard for precedent, and disdain for congressional judgment. And in that way, it greenlights redistricting plans that will disable minority communities, in Louisiana and across the nation, from electing, as majority communities can, representatives of their choice. What if the districts in which minority citizens exercise voting power are sliced up and the pieces appended to districts in which they can play no meaningful role? The majority tells us that the inability to make out a Section 2 claim will just be a mark of the nation's progress and therefore cause for celebration. I dissent. The Voting Rights Act is, or now more accurately was, one of the most consequential, efficacious, and amply justified exercises of federal legislative power in our nation's history. It was born of the literal blood of Union soldiers and civil rights marchers. It ushered in awe-inspiring change, bringing this nation closer to fulfilling the ideals of democracy and racial equality, and it has been repeatedly and overwhelmingly reauthorized by the people's representatives in Congress. Only they have the right to say it is no longer needed, not the members of this court. I dissent, then, from this latest chapter in the majority's now completed demolition of the Voting Rights Act. Part 1. I begin with some history. both with what led originally to the Voting Rights Act and with how the current Section 2 came to be. The point is not to deliver a eulogy for the law, though in truth the court's step-by-step slaying of voting rights now makes one appropriate. Rather, the object is to reveal how far today's decision repudiates past and rightfully still controlling congressional choices. As I'll later explain, the majority now demands that vote dilution plaintiffs muster proof of racially discriminatory motive. In that way, the decision echoes an earlier one of this court, which also held that Section 2 should function as an intent test. See Mobile v. Bolden. But Congress, as you'll soon see, amended Section 2 to reject that view. In light of the way voting discrimination had operated since the 15th Amendment's adoption, Congress instead drafted Section 2 to bar the use of any electoral mechanism that would result in minority citizens having less opportunity than non-minority citizens to choose their political representatives. Section A. In the wake of the Civil War, Congress enacted and the states ratified the 15th Amendment to ensure the enfranchisement of Black Americans. Nearly 200,000 black men had fought in the Union cause. When the fight is over, General Sherman counseled, "The hand that drops the musket cannot be denied the ballot." And millions more African Americans had just become citizens, giving them a claim on political rights. The 15th Amendment responded with a clarion promise of racial equality in voting. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. The amendment's passage was a momentous occasion. It appeared to affirm that a mere few years after slavery's end, African Americans had become equal members of the body politic. President Grant, in a message to Congress, called the amendment the most important event that has occurred since the nation came to life. Black Americans similarly referred to the amendment as the nation's second birth. At one of the many celebrations ratification sparked, Frederick Douglass rejoiced that those just released from bondage were now placed upon an equal footing with all other men. Never, he declared, was revolution more complete. But all the hosannas were many years premature. In the century that followed, the 15th Amendment proved little more than a parchment promise. Violence and intimidation were ever-present ways to deny black citizens their right to vote, but often force was not needed because state laws could well enough accomplish that goal. Especially in the South, states soon put in place a host of facially race-neutral devices to systemically disenfranchise African American citizens. Poll taxes, literacy tests, good character exams, property qualifications, convoluted registration processes, all these and more, when combined with administrative discretion, effectively suppressed the black vote, without much affecting the white one. Congress could have acted. The 15th Amendment gave it the power to enforce minority voting rights by appropriate legislation, but for decades it sat mute while facially race-neutral voting rules succeeded in rendering the right to vote illusory for black Americans. Louisiana's post-Reconstruction rules, to cite the most pertinent example, took less than a decade to drive the number of black registered voters from 130,000 in 1896 to 1,342 in 1904. The numbers did not begin to climb until the end of World War II, when black soldiers returned from other battlefields, and even then only slowly. Congress's initial efforts to counter voting discrimination in the Civil Rights Acts of 1957, 1960, and 1964 did little but prove the difficulty of the task. Each of those statutes authorized the Attorney General to seek injunctions against public and private interference with the right to vote on racial grounds. But time and again, states found ways to evade the ensuing court orders. They merely switched to discriminatory devices not covered by the court decrees, finding yet new race-neutral rules, there seemed an endless number, that would maintain the disparity between white and black voting power. Congress thus learned of the unremitting and ingenious methods states could use to resist African American enfranchisement. Protecting minority voting was like battling the Hydra. Whenever one form of voting discrimination was identified and prohibited, others sprang up in its place. The Voting Rights Act of 1965 represented Congress's most determined effort to stop the cycle. Selma's Bloody Sunday had galvanized the nation to finally confront racial disenfranchisement. Now, Congress enacted legislation making use of a double-barreled approach to ensure the 15th Amendment's enforcement. Section 5 of the Act required that states or localities with a history of racial voter suppression obtain Department of Justice approval before implementing new voting districts or rules. An administrative review process thus would impede, at least until this court in Shelby County stopped it, the ever-inventive efforts of certain jurisdictions to deny or minimize minority voting. Meantime, Section 2 provided judicial recourse for victims of voting discrimination in all jurisdictions. That provision prohibited any election rule or practice that would deny or abridge the right to vote, thus imposing a permanent nationwide ban on racial discrimination in voting, or so the court assured the country when disabling Section 5. Taken together, Congress thought the two mechanisms could forever banish the blight of racial discrimination in voting, effectively countering states' constantly morphing methods of suppressing minority ballots. Section B. After the Act's passage, and partially because of its initial success, those methods more and more focused on vote dilution. The Act led to a large increase in minority voting registration. In just 5 years, almost as many African Americans registered to vote in 6 southern states as in the entire century before 1965. And the Act mostly halted state efforts to prevent those new voters from casting ballots at all. So the states, as Congress noted when reauthorizing Section 5 in 1975, resorted to measures which would dilute increasing minority voting strength. Efforts to minimize minorities' voting power took several forms. One was to use at-large voting. A majority white municipality, for example, might exclude all African Americans from its city council by scrapping geographic districts in favor of citywide elections. Another common dilution mechanism was just to redraw single-member districts. Minority citizens could be packed, a racial community large enough to constitute a majority in 2 normal districts, and therefore capable of electing 2 representatives might be crammed into a single district instead. Or else minority citizens could be cracked, as in the hypothetical introducing this opinion. Then, voters would be dispersed across multiple districts so they could not muster a majority in any. In either event, a majority citizen's vote would carry less weight than it did previously or than it would in another hypothetical district. This court soon held in White v. Register that such practices could be unlawful because of their effects, more specifically because they result in unequal electoral opportunities for minority citizens. Attend closely here because White becomes the template for the current version of Section 2. The plaintiffs in White challenged a Texas districting scheme that established multi-member districts in 2 counties with concentrated urban populations, even while using single-member districts nearly everywhere else. The effect of the scheme, the plaintiffs charged, was to minimize the voting strength of racial groups, both African Americans and Mexican Americans, by putting them in a broad county-wide district in which their votes would be swamped. In addressing that claim, the court initially stated that it was not enough to show that the districting scheme prevented the minority groups from achieving proportional representation, legislative seats in proportion to their population, but that did not mean that the plaintiffs had to show that the state had acted with discriminatory intent. Rather, the court held the plaintiffs could prevail on a different kind of showing that a scheme's effect was to minimize the voting strength of racial groups. Under the court's test, there was unlawful vote dilution if the political process was not equally open to participation by a racial group so that its members had less opportunity than others to participate in the political process and elect legislators of their choice. The court in White found that test satisfied under a totality of the circumstances inquiry, which looked to how the multi-member districting scheme operated when overlaid on historical, social, and political realities. As part of that analysis, the court noted the history of official racial discrimination in Texas and the persistent use of racial campaign tactics in elections. But beyond such intentional race-based action, the court looked to how the current residual effects of past discrimination, including disparities in matters like housing, education, and employment, had political consequences. Similarly, with respect to Mexican Americans, the court considered evidence of cultural and language barriers to political participation. And finally, the court honed in on political data itself, including voter registration and infrequent election of Black or Hispanic candidates in majority white districts. When all those factors were combined, in what the court called an intensely local appraisal, the impact of the multi-member districts clearly emerged, those districts denied minority voters equal access to the political process, specifically in the election of state representatives. Footnote 1. The majority's description of the white court's totality of the circumstances analysis gives a false impression. According to the majority, the court's rationale rested on evidence that gave rise to an obvious inference that the state acted with discriminatory purpose or intent. That might be so of pieces of the evidence the court relied on, for example, the use of racial campaign tactics by a party-affiliated organization. And it is of course true that evidence of disparate impact can be of such magnitude, in this sphere as well as others, as to indicate illicit intent. But the court was crystal clear that its review of local conditions encompassed things neither improper nor invidious, and indeed its opinion reads more like a fine-grained report on political and social conditions than, as the majority would have it, a criminal bill of particulars. Most important, and as even the majority admits, the court never suggested that the ultimate point of its analysis was to gauge the state's intent. Rather, the point was just what the court said, to decide whether Texas's districting scheme in fact operated to dilute minorities' voting strength. Carrying on. Just 7 years later, however, the court did an about-face, now requiring a showing of discriminatory intent to succeed on a vote dilution claim. In City of Mobile v. Bolden, the plaintiffs challenged an at-large election system for a 3-member city commission. Under that system, Mobile's black population, which made up 35% of the total, had never managed to elect a candidate of its choice. But the court did not embark on the kind of analysis employed in White to determine whether the system diluted black votes. Instead, the court's controlling opinion held that Section 2 merely restated the prohibitions of the 15th Amendment, which barred only intentional discrimination, and the plaintiffs had produced no evidence of discriminatory motive. They could, the court noted, as though it were the end of the matter, register and vote without hindrance. That their chosen candidates happened to always lose was beside the point. Because they could not show that the city had purposefully excluded them from participating in the election process, the court held they had no viable Section 2 suit. Bolden, as the majority notes, triggered an avalanche of criticism both in the media and within the civil rights community. This court recently noted a few of the assessments. The biggest step backwards in civil rights to come from the court since the Voting Rights Act's passage, and a major defeat for blacks and other minorities fighting electoral schemes that exclude them from office. The problem, as even the majority recognizes, was that a focus on discriminatory intent rather than discriminatory effects would defeat worthy claims because of the difficulty of proving intentional discrimination. It is the rare legislature, as the history of voting discrimination shows, that cannot camouflage racial targeting with race-neutral justifications. For that reason, Bolden brought vote dilution claims to a near standstill. The Department of Justice shelved the dilution cases it had intended to bring, and private plaintiffs filed just 10 such suits in the next year, compared with 60 the year before. States, it seemed, could make minority votes meaningless without ever running into the Voting Rights Act. But then Congress stepped in to reverse Bolden's intent requirement and create the statute existing today. The House began the process with a simple change to Section 2's text. It replaced the words "to deny or abridge" with the phrase "in a manner which results in a denial or abridgment of," to make the section look like this. Quote, "No voting qualification or prerequisite to voting or standard, practice, or procedure shall be imposed or applied by any state or political subdivision in a manner which results in a denial or abridgment of the right of any citizen of the United States to vote on account of race or color." End quote. But a Senate subcommittee led by Senator Orrin Hatch objected. It thought the House's amendment would always require racially proportional representation and advocated keeping Section 2, as construed by Bolden, just as it was. The impasse was resolved by Senator Bob Dole in the Judiciary Committee through the addition of a subsection codifying the White decision. Recall that White had rejected proportional representation as the standard for vote dilution claims. Now Senator Dole, while retaining the House's results in language, added a provision to do the same thing. And yet more important for present purposes, Senator Dole took language from White to clarify when a state would violate the ban on electoral rules that result in a denial or abridgment of voting. a violation is established, the dull, but really the white, language stated, quote, if, based on the totality of circumstances, it is shown that the political process leading to nomination or election in the state or political subdivision are not equally open to participation by members of a racial group, in that its members have less opportunity than other members of the electorate to participate in the political process and to elect representatives of their choice, end quote. That elaboration of when the effects of an electoral rule would cause a violation of Section 2 received bipartisan support. The amended Section 2 passed both the House and the Senate by huge majorities, and in June 1982, President Reagan signed it into law. An oft-cited Senate report explained just what the 1982 amendment had accomplished. The new Section 2 repudiated Bolden's intent requirement and adopted White's results test. An intent test, the report stated, imposed an inordinately difficult burden for plaintiffs. Even when state actors had purposefully discriminated, they would likely be able to offer a non-racial rationalization supported by a false trail of official resolutions and other legislative history eschewing any racial motive. The proof lay in what had happened after Bolden, when even suits involving egregious vote dilution had failed. And in any event, the report continued, the Bolden intent test asked the wrong question. The right question was instead the one White, and now the statute, asked. Whether minorities have equal access to the process of electing their representatives. In applying the new Section 2, the report instructed, courts should assess the impact of the challenged practice based on objective factors to determine whether it worked to minimize or cancel out the voting strength and political effectiveness of minority groups. The Senate report also noted this court's holdings recognizing Congress's constitutional authority to focus the Section 2 standard on results. It is Hornbook law, the report explained, that the 15th Amendment grants Congress broad power to enact legislation reasonably adapted to protect citizens against the risk that their constitutional right to vote will be denied. So even though the 15th Amendment itself barred only intentional discrimination, Congress could enact legislation extending to discriminatory effects. Indeed, the report observed this court had held as much 2 years earlier when it approved Section 5's broad effects-based scope. In Section 2 as well, proper enforcement of the 15th Amendment necessitated a results test. For one thing, voting rules with discriminatory results perpetuate the effects of past purposeful discrimination. And anyway, the report again emphasized, the difficulties of proving motive would create a substantial risk that intentional discrimination would go undetected, uncorrected, and undeterred. So Congress made a choice that was as considered comes, to ensure that results alone could lead to liability under Section 2. Congress in 1982 knew all about this nation's history of racially discriminatory voting practices. It knew that even when states could no longer deny ballots to minority citizens, they still might try to give their votes no or minimal weight. And Congress knew that those efforts did not come tagged as race-based. To the contrary, they were race-neutral on their face and likewise were publicly backed by race-neutral justifications. So Congress renounced as strongly as it could Bolden's decision to limit Section 2's ban to intentional discrimination. It made sure instead, as this court recently explained, that Section 2 would turn on the presence of discriminatory effects. And more precisely, that this section would turn on whether, given all relevant circumstances, an electoral rule would leave minority voters with less opportunity than non-minority voters to elect representatives of their choice. There is a way to decide this case consistent with that fully permissible congressional choice and a way not. In the next part, I show how 40 years' worth of this court's case law would address the vote dilution claim involved here. After that, I address what today's majority does. Footnote 2. A wrinkle here is that the suit directly before us involves a claim of racial gerrymandering under the 14th Amendment, not of vote dilution under Section 2. As I will later discuss, the elements of the two have always been poles apart, with a dilution claim turning on an election rule's effects and a gerrymandering claim turning on its purpose. But this gerrymandering suit arose out of a prior dilution suit's success. The plaintiffs here attacked the districting plan that Louisiana devised to remedy the vote dilution previously found, and the majority chooses to resolve this suit by focusing on the earlier one, holding that the plaintiffs here succeed because the court in the earlier litigation did not apply the majority's brand new understanding of Section 2. So I too focus on how to decide a vote dilution claim under Section 2 and do not address other issues implicated in a gerrymandering suit. Carrying on. Part 2. This court first construed the amended Section 2 in Thornburg v. Jingles, establishing there a framework, like the new statute itself, based on White. That framework has governed vote dilution claims for the last 4 decades, and indeed, just 3 years ago in Allen, we unequivocally reaffirmed it when sustaining a vote dilution challenge to an Alabama redistricting scheme. Had we proceeded along the same road today, we would have treated the vote dilution challenge to Louisiana's scheme in the same way. Jingles began, as Allen recently noted, by describing what Section 2 guards against. The essence of a Section 2 claim, Jingles explained, is that an electoral rule or practice interacts with social and historical conditions generally caused by past intentional discrimination to cause an inequality in the opportunities enjoyed by black and white voters. Such an inequality exists when the challenged rule operates to minimize or cancel out minority voters' ability to elect their preferred candidates. And the risk of that minimization or dilution is greatest when minority and majority voters consistently prefer different candidates, and the minority voters are submerged in a majority voting population that regularly defeats their choices. Footnote 3. The majority, in describing the legal background to this case, briefly criticizes our Jingles opinion for spending too little time with Section 2's text and too much with the Senate Judiciary Committee report. The author of today's decision made the same point in Allen, in his then dissenting opinion. But the erstwhile majority there rejected the argument, explaining that, whatever changes have occurred in statutory interpretation, Jingles effectuates the delicate legislative bargain that Section 2 embodies. It does so, as will soon become evident, by grounding its framework in Section 2's ban on electoral rules that, in all the circumstances, result in giving minority voters a lesser opportunity than others to elect representatives of their choice. And it does so, too, by relying on, indeed partly copying, this court's analysis in White, which was the indisputable basis for Senator Dole's textual compromise. Carrying on. To get at that issue, Jingles initially requires a Section 2 plaintiff asserting vote dilution to satisfy 3 preconditions. First, the minority group allegedly harmed must be sufficiently large and geographically compact to constitute a majority in a reasonably configured district, meaning one comporting with traditional districting criteria. Second, the identified minority group must be politically cohesive, meaning that its members mainly vote for the same parties or candidates. And third, the majority in the district must vote sufficiently as a bloc to enable it, usually, to defeat the minority's preferred candidate. Those 3 factors taken together serve a gatekeeping function. They permit a vote dilution suit to proceed only if a plaintiff can show that minority voters would elect a representative of their own choice in some reasonably drawn electoral district, but that racially polarized voting in the district as actually drawn will usually impede their ability to do so. That threshold test is not easily met. To satisfy the first factor, a plaintiff will have to suggest alternative districting plans complying with such traditional criteria as compactness, contiguity, and respect for geographical boundaries and political subdivisions. And as Allen recently described, the inability to offer such substitute maps has doomed a good many vote dilution suits. Similarly, to satisfy the second and third conditions, the plaintiff must show the existence of racially polarized voting, generally through statistical evidence of historic voting patterns. It is never enough in a Section 2 suit to rely on assumptions about how individuals will vote based on their ethnic or racial background. Instead, plaintiffs must prove racial bloc voting. Given those requirements and the steady decline in both residential segregation and racially polarized voting, which make them harder to meet, only strong vote dilution claims can today get out of the gate. And beyond Jingles' preconditions lies the totality of circumstances inquiry that migrated from White to Section 2's text. To find under that test that the political process is not equally open to minority voters, a court must make, so Jingles held lifting from White, an intensely local appraisal of how the challenged electoral rule operates against the backdrop of past and present racial realities. The objective factors to be considered include the state's history of voting-related discrimination, its experience of racial appeals in political campaigns, and its track record of electing minority citizens to office. So too, the inquiry may involve appraising the effects of past discrimination on economic and social conditions that hinder minority citizens' ability to participate effectively in the political process. Equally, though, the totality test weighs the strength of a state's interest in maintaining a given electoral practice, and the variety of matters to be assessed does nothing to detract from the test's bite. By digging deep into local context, the totality inquiry implements Congress's directive that a simple lack of proportional representation cannot make out a Section 2 claim. And when superimposed on Jingles's threshold conditions, the test ensures that Section 2 will work as intended, to limit liability to cases where electoral rules in fact deny minority voters equal opportunity in the political process. Understood in that way, Allen explained just 3 years ago, Jingles has governed our Voting Rights Act jurisprudence since it was decided. More, Congress has never disturbed our understanding of Section 2 as Jingles construed it. And more, we have applied Jingles in one Section 2 case after another to different kinds of electoral systems and to different jurisdictions in states all over the country. And yes, still more, this time invoking stare decisis, we declined to adopt an interpretation of Section 2 that would revise and reformulate the Jingles framework that has been the baseline of our Section 2 jurisprudence for nearly 40 years. One might have thought the matter settled. Footnote 4. The majority's view that Allen did not address the central issue here, the meaning of Section 2 and appropriate content of the Jingles framework, is one of the more perplexing aspects of today's decision. I will have more to say about that assertion below, but for now I invite readers to do a bit of exploration on their own. Just search for every quotation from Allen in this opinion, in this paragraph of course, but all the rest too, and ask yourself whether it is credible that Allen did not address the question of our understanding of Section 2 as Jingles construed it. Better yet, go read all of Allen. You will find that, on page after page, it discusses precisely that issue, and offers a reading of Section 2 and Jingles perfectly consonant with this dissent and fundamentally at odds with today's majority opinion. Carrying on. In that settled view, a paradigmatic case of a Section 2 violation is the cracked circle hypothetical opening this dissent. If you refresh your memory, you'll instantly see why. The black electorate could form, indeed did form, a reasonably configured district. The circle in the middle of the state complies with traditional districting criteria of contiguity, compactness, and respect for political subdivisions. So Jingles's first precondition is met, and the racially polarized voting in the state ensures that the second and third are met as well. The black electorate within the circle and the white population surrounding it vote as blocks and for different candidates. So when the black voters are dispersed among 6 predominantly white districts, they lose all their electoral influence. Or, as we recently described such a situation, black voters have the potential to elect a representative of their own choice in a possible district, but racially polarized voting prevents them from doing so in the district as actually drawn because they are submerged in a larger white voting population. That means a Section 2 suit will be decided based on the totality of the circumstances. And as to that, I have posited facts making the inquiry straightforward. Recall that the hypothetical state has a long history of racial discrimination which continues to show up, in manifold ways, in social conditions and political activity. So Section 2, before today, would have stopped the hypothesized cracking plan and, in so doing, worked as Congress intended, to give black voters no less a chance than their white neighbors to participate in the political process and elect their preferred representatives. And my hypothetical is not so different from the Louisiana districting scheme that was challenged in the dilution suit underlying this case. It is just that instead of arguing about the need for one majority-minority district, the plaintiffs in that suit were asserting the need for a second. As the majority relates, Louisiana drew its post-2020 census map with 1 mainly black district and 5 mainly white ones. For context, Louisiana's population is about 1/3 African American. The dilution plaintiffs alleged that there was another natural, i.e., politically cohesive and geographically contiguous, black majority district which the Louisiana legislature had effectively cracked. The residents of that possible district wound up dispersed among the state's other districts where, given racially polarized voting, their preferences would count for nothing. According to the plaintiffs, that plan violated Section 2 by giving black voters less opportunity than their white counterparts to elect representatives of their choice. Based on a voluminous record, including mountains of statistical data and 5 days of testimony, the district court found that the plaintiffs were likely to prevail. See Robinson v. Ardoin. The proposed second district, in which black voters could easily form a majority, was reasonably configured according to traditional districting criteria. And without that district, black voters' choices would be swamped. The evidence showed that as few as 12% of white voters in Louisiana would support black preferred candidates in statewide contests. With the jingles preconditions thus satisfied, the court assessed the totality of the circumstances and found that it too supported relief. And so the court ordered the state to draw a new map. The court thus applied, in an altogether unexceptional way, the framework used for the last 40 years to evaluate Section 2 vote dilution claims. The court followed jingles along with the 2 fistfuls of this court's decisions affirming its framework. And most crucially, the court followed Section 2 itself, because all our prior decisions faithfully implemented the fundamental choice Congress made in amending that section to make liability turn, as the court did in White, not on the motives behind, but on the results of an electoral practice like districting. Part 3. The majority today does just the opposite. Under the guise of updating the jingles framework, the majority transforms it, and in so doing betrays Congress's choice. At each of Jingles' steps, the majority imposes new proof requirements serving a common objective, to convert an effects test as commanded by Congress into a purpose test as preferred by this court. Nearly half a century ago, Congress amended Section 2 to repudiate Bolden's limitation of that provision's reach to intentional discrimination. Today's decision returns Section 2 to what it was under Bolden. Now, as then, vote dilution plaintiffs will have to show more than vote dilution. They will have to show as well race-based motive. Now, as then, that requirement will make success in their suits nearly impossible, even if an electoral practice has in fact minimized or canceled out minority citizens' voting strength. It is as if Congress had never amended Section 2. I first show how that is the consequence of today's updating. I then address how the majority attempts to justify what it has done. The upshot is that the majority, without any good reason, has overturned Congress's studied determination, along with this court's precedents upholding it, about how to rectify racial inequalities in electoral politics. Section A. Let's first drop the majority's misleading label. What the majority gives us today is not an updated jingles framework. It is its own thing, deserving of its own name. Maybe the Callais contrivance, or if that seems too immediately pejorative, just say that what the majority does today is to impose the Callais requirements. At their base, all those requirements have the same function. They force a vote dilution plaintiff to prove that a state adopted an election rule with racially discriminatory intent. On the majority's view, a rule diluting minority votes, even making them count for nothing, poses no problem if motivated by non-racial factors. So a state has free rein to use traditional districting factors even when they minimize or cancel out minority votes. And yet, more practically important, a state may, so says the majority, draw districts for any political purpose, including for a purely partisan purpose, that is, to increase one party's electoral strength, no matter their racial effects. For that reason, the majority insists a Section 2 plaintiff has a special burden to overcome. The plaintiff must disentangle race from politics by proving that the former drove a district's lines. In other words, he must show that the state, in drawing that district, had not a political but instead a racial motivation, that it acted for the specific purpose of weakening a minority group's voting influence. The new Callais requirements, as I'll soon discuss, are all conceitedly designed to ensure that the plaintiff is held to that special burden, which, as the Congress amending Section 2 well understood, is nearly insuperable. Footnote 5. In responding to this dissent, the majority, on its opinion's penultimate page, appears to disclaim this reading. The majority notes first, and this is true enough, that the dissent states over and over again that our decision requires a Section 2 plaintiff to prove discriminatory intent. And then the majority's response: no, a vote dilution plaintiff need show only that a redistricting denies members of a racial group the same opportunity as other voters to elect the candidates they prefer. That formulation is right, and as shown above, it demands an inquiry into the effects of a scheme on voters' opportunity to elect candidates. Similarly, the majority claims that it is doing just what White did. And White, recall, made an intensely local appraisal of whether an election scheme, when overlaid on historical, social, and political realities, in fact operated to dilute minority voting strength. In other words, applied an effects test. So the majority closes its opinion by suggesting it is not requiring a vote dilution plaintiff to present evidence of discriminatory intent, which, if true, would be welcome news, and welcomer still if lower courts took those last words seriously and allowed Section 2 claims to succeed even absent proof of race-based purpose. But I suspect they will not, because they, like I, will have read the many pages leading up to the majority's coda. And those pages, both in setting out and in explaining the Callais requirements, make clear that a Section 2 plaintiff has a special burden to demonstrate that racial, rather than political or other, reasons drove a district lines, i.e., that the state intentionally drew its districts to afford minority voters less opportunity. So what the majority hopes to accomplish by its last-minute attempt to associate itself with an effects inquiry is something of a mystery. To try to disguise what it is really doing? To somehow absolve itself of responsibility? Or could it just be that in responding to this dissent, the majority can do nothing but agree? Carrying on. But before becoming so granular, it is worth asking what precedents support the majority's insistence on evidence of racially discriminatory intent. By now, I hope no reader will think those precedents concern Section 2. Our Section 2 precedents are quite to the contrary. It is patently clear, Allen recently summarized, that because Section 2 liability turns on the presence of discriminatory effects, not discriminatory intent, a plaintiff need not demonstrate a purpose of racial discrimination. So the majority must go further afield. Its citations regarding the plaintiff's special burden of showing that race rather than politics or anything else motivated the state are from this court's racial gerrymandering jurisprudence. But racial gerrymandering claims and vote dilution claims are, despite some superficial similarities, different legal beasts. Plaintiffs bringing the former need not have suffered vote dilution, nor do they invoke Section 2. Their claim is simply that purposeful racial sorting, all on its own, irrespective of any vote-minimizing effects, violates the 14th Amendment. Footnote 6. The first case to recognize a racial gerrymandering claim was Shaw v. Reno. There, 5 white residents objected to the North Carolina legislature's decision to create 2 majority black districts. But the plaintiffs did not and could not argue that the map diluted their votes. Instead, they contended that the legislature's deliberate race-based segregation of voters violated their 14th Amendment right to a color-blind electoral process. The court held that the plaintiffs had a cognizable claim that the 14th Amendment could be violated by such intentional sorting. And later decisions elaborated that a racial gerrymandering claim would trigger strict scrutiny if a plaintiff proved that race was the predominant factor motivating the drawing of district lines. Carrying on. In such a case, as I have elsewhere explained, it is of course essential to have proof of race-based purpose. But not so when the claim is for vote dilution, brought under a statute that, in Allen's words again, clearly rejected treating discriminatory intent as a requirement for liability. In that context, putting a burden on the plaintiff to show that district lines were driven by racial rather than political or other factors is to reject everything this court has ever said about Congress's Section 2 choice. The majority's misplaced focus on purpose shows up first and most crucially in recasting the first Jingles precondition. That threshold requirement, as the majority acknowledges, has always functioned to ensure that a minority community is large and geographically compact enough to elect a representative of its choice in a reasonably configured district. So the illustrative maps most vote dilution plaintiffs submit show exactly that, how a reasonable majority-minority district could be created. But now the majority says the first precondition must be devoted to flushing out discriminatory purpose on the part of the state by excluding the possibility that its districting plan arose from non-racial motives. So the plaintiff's illustrative maps have to satisfy as well or better than the state's own every permissible districting criterion the state specifies, including, and this is the kicker, all its political goals. Those goals include the partisan distribution of districts within the state, say that 6 seats should be held by one party and none by the other. Likewise, they apparently encompass the partisan balance within any district, say to ensure a specific margin of victory for a candidate. Only if the plaintiff's maps achieve all those goals just as well as the state's plan, the majority intones, can those maps help to disentangle race from politics, or, otherwise said, show that the state's plan was driven by racial motives. That change alone is likely to bring vote dilution suits, already hard to win, to a screeching halt. To see how, return to the circle hypothetical. Until now, the paradigmatic case of vote dilution because the state there prevents black but not white voters from having an opportunity to elect their preferred representative as Section 2 demands. The legislature, recall, has sliced up the majority black circle district into 6 pie pieces, with each added to and only marginally affecting a predominantly white district. Before today, the first jingles precondition is met with ease just with a picture of the old district. Yes, that picture would say black voters can form, in fact, have formed, a majority in a district drawn consistent with traditional principles. But after today, suppose the state, per the majority's instructions, asserts that it cracked the African American electorate because it wants 6 safe Republican districts. Now, the plaintiff's illustrative map insists the majority must also have 6 safe Republican districts, but given that race and partisan preference are linked with black citizens mainly voting Democratic, such a map cannot be drawn. Any map with a majority black district will not be a map with all Republican seats. And so, the majority decides a Section 2 suit must fail at the outset, even though the state has deprived black citizens of any opportunity to elect representatives of their choice. At least where such common race-based voting patterns hold, states now have an automatic political gerrymandering defense to vote dilution claims. Yet more, the majority's reworking of Jingles' first precondition, contra its assurance, will doom vote dilution suits even when majority and minority voters support different candidates within a single party. Take an example offered by the Solicitor General, whose ideas about how to upend Jingles the majority largely filches. In that hypothetical, black, Hispanic, and white voters residing in Harlem all vote mainly for Democrats, but have different candidates of choice. The Solicitor General maintains that if the district lines favor one of those racial groups, let's say the black voters, that's the sort of situation where Section 2 could come in. The majority agrees because there the state's preference for one party could not explain the district lines drawn. But under the majority's test, the legislature could easily invoke other political as well as non-political goals to justify the lines and thus preclude liability. Suppose the state asserted that it drew the lines to protect an incumbent who just so happened to be favored by black residents. Or suppose the state said it wanted to increase or decrease or maintain the district's partisan competitiveness created by its ratio of Democrats to Republicans, which just coincidentally gave black voters more influence. Or suppose the state said that it wished to keep the existing district's core intact, itself a frequent districting criterion, rather than make the changes needed to give non-black voters greater electoral opportunity. The possibilities are endless, and each would have the same result. Because the Section 2 plaintiff's map could not as well advance the bespoke political or other goals favoring the black voter's chosen candidate, the suit would fail, even if non-black votes election year in and election year out had been made to count for nothing. Congress, as should by now be clear, made a different choice. In amending Section 2, Congress opted for the effects test of White over the purpose test of Bolden. And it did so largely because of the unfeasibility of countering a state's non-race-based justification for a given districting decision. Such a demand, the authors of the Senate Compromise explained, would impose an inordinately difficult burden, precluding a remedy for even the most egregious cases of vote dilution. Yet that is exactly the burden the majority makes Section 2 plaintiffs bear, and at the first threshold condition. The majority makes no effort to explain how minority voters can meet its new requirement, how they can devise a map satisfying, at least as well as the state's own, each of the state's asserted political and other goals while also creating or maintaining a majority-minority district. Footnote 7. If that assignment does not sound fanciful enough, the majority imposes yet a weirder requirement on plaintiffs' maps, and one Allen specifically rejected. In drawing illustrative maps today's majority holds, plaintiffs cannot use race. What exactly the majority means by use is left unclear, but assuming the majority means to bar plaintiffs from taking account of race when showing how a majority-minority district could be created, it is both incoherent and inconsistent with Section 2 and Jingles. I cannot do better than Allen did in explaining why. In that case, Alabama took much the view the majority does, that a Section 2 plaintiff's illustrative maps cannot have been based on race. But Allen spurned the notion. Section 2 itself demands consideration of race, we explained, because its implementation requires knowing whether additional majority-minority districts can be drawn. And indeed, we continued, that is the whole point of the maps adduced at the first step of Jingles. To say that those maps must be race-blind is thus to reject the Jingles framework outright, really to insist that it be overruled. Quite right. Carrying on. Or assuming they cannot draw such a map, whether they may produce other evidence of racially discriminatory motive to meet or else bypass the first Callais requirement. Or if they may offer such evidence, how, if at all, it might differ from the kind generally needed to prevail in a racial gerrymandering suit, i.e., direct evidence like leaked emails from legislators professing the desire to reduce a racial group's voting strength. Presumably, the majority thinks that the details do not much matter. Once Section 2 has been transformed via a change to Jingles' first precondition from a ban on racially dilutive effects a la White to a ban on race-based motives a la Bolden, virtually all vote dilution cases will fail anyway. The majority has thus nullified Congress's decision to provide a remedy, without proof of intent, for state action that results in a minority group's lesser opportunity to elect representatives. But the majority is not yet done thwarting Congress's objective. Maybe in some exceptional case a state will fail to assert a goal like political gerrymandering that the plaintiff's map cannot replicate. Then the majority's makeover of the second and third Jingles preconditions comes into play, again to convert Section 2 into its opposite, a statute turning on discriminatory intent, not effects, contra Allen. Until today, the second and third preconditions focused simply on racially polarized voting. Plaintiffs had to show that minority citizens vote cohesively but cannot elect their preferred candidates because majority citizens vote as a bloc for others. Now, the majority introduces a new requirement to impede Section 2 suits. The plaintiffs must provide an analysis that controls for party affiliation. That means if minority citizens vote mainly for one party and majority citizens vote mainly for another, none of that difference can count towards meeting the second and third preconditions. So in offering evidence of polarized voting preferences, a plaintiff must remove from the equation polarized voting preferences. For in most places, even if not in Harlem, partisan difference is the way those divergent preferences are expressed, and the way one racial group's vote can swamp another's again and again. The majority argues that its new requirement is needed to rule out the possibility that the state districted as it did for partisan rather than racial reasons, but the state's intent is not what is supposed to matter in a Section 2 suit. Congress amended Section 2, need I say again, to ensure that it would function as an effects test. The majority wishes a different statute and makes it so. Footnote 8. As with the first Callais requirement, the majority does not address whether plaintiffs can bypass this second requirement if they have evidence that the districting decision was driven by racial considerations. In other words, what happens if the second Callais requirement is unsatisfied because race and partisan preference go hand in hand, but there is still evidence that race drove the district's lines? Presumably, the claim should be able to proceed to the totality test, but the majority leaves us guessing. Carrying on. And so too for Section 2's totality of circumstances inquiry. Should some litigant miraculously arrive at that stage of a vote dilution suit, he will find it transformed. The totality test, today's majority insists, must focus on only one thing: intentional present-day voting discrimination. But that is neither what Congress said nor what Congress meant when it added the phrase totality of circumstances, obviously referring to multiple things, to Section 2. Derived from White, that phrase demands the kind of intensely local appraisal the court there used to evaluate a districting plan's impact on a minority group's access to the political process. That appraisal, of course, included evidence relating to intentional present-day voting discrimination, but it included as well the continuing effects of past discrimination, and not only in politics but in other spheres of life. The majority's flattening of the prescribed inquiry mirrors Bolden's conversion of White into a test for illicit motive. But it was precisely to reverse that shift that Congress enacted Section 2's current totality language. The consequences of the new Callais requirements show up immediately in the majority's disposition of this case. The district court may have heard 5 days of testimony, may have properly applied the old Jingles factors, may have explained in 110 fact-intensive pages why the vote dilution plaintiffs were likely to prevail, but the majority thinks it easy to overturn all that court's work in a few paragraphs. The plaintiffs flunked the new first Jingles precondition because their illustrative map, although showing a reasonably configured majority-minority district, failed to meet the state's political goal of protecting every incumbent Republican representative. The plaintiffs came up short on the new second and third preconditions because their showing of racially polarized voting, that black and white voters consistently support different candidates, did not control for partisan preferences. And anyway, the plaintiffs could not prevail under the new totality of circumstances test because they did not show that the state's challenged map was the result of intentional racial discrimination. All the plaintiffs' evidence, like the dearth of black preferred candidates ever elected in the state, could just be the result of politics. Bang, bang, bang. It is like shooting fish in a barrel. Once the state can rely on any political goal of its devising, and once inter-party racial polarization serves to undercut rather than strengthen a vote dilution claim, no plausibly existing evidence in this case could have made a difference. And nothing is special about this majority-minority district, as the Callais requirements have eliminated it today, so they will eliminate other and older ones in the years to come. Recall that this majority black district, which is District 6, was Louisiana's second. The state's District 2 has had a black majority since 1983 when a vote dilution suit forced its creation. If Louisiana were tomorrow to slice up District 2, dispersing its black residents among the rest, it is hard to see how the now judicially amended Section 2 could stand in the way. The state presumably would assert as its political goal an all-Republican congressional delegation. In other words, it would announce a partisan gerrymander. And because of the severe racial polarization in the state, that goal would be incompatible with maintaining District 2 as is. So those advocating for its majority-minority composition would almost surely lose at the first Callais requirement, and as above at the others as well. Repeated often enough across the country, the same districting practice, really hinging only on the partisan ambitions or restraint of state legislatures, could destroy most of the majority-minority districts that in the past 40 years the Voting Rights Act created. The Callais requirements have thus laid the groundwork for the largest reduction in minority representation since the era following Reconstruction. Under cover of updating and realigning the greatest of statutes, the majority makes a nullity of Section 2 and threatens a half-century's worth of gains in voting equality. Section B. There is only one special burden appropriate to deciding this case, and it is not the utterly novel one that the majority imposes on Section 2 vote dilution plaintiffs to disentangle state motives. Rather, it is the well-settled one that the court itself must meet before overturning precedent about the meaning of a statute. Our law is clear. Stare decisis, the presumption that today's court should stand by yesterday's decisions, carries enhanced force when the decision in question interprets a statute. That is because our statutory, unlike our constitutional rulings, can always be changed by Congress itself. Just recall how Congress rejected our decision in Bolden. When this court has said what a statute means and Congress has said nothing to the contrary, a superpowered form of stare decisis takes hold, which only a super special justification can overcome. Or, as one justice has put it, there is in that circumstance a nearly impregnable shield protecting the decision. Minerva Surgical Inc. versus Hologic Inc., Justice Alito dissenting. This court, as noted above, invoked that shield to uphold jingles just 3 terms ago. In Allen, Alabama proposed a way of limiting jingles to make it harder to win a vote dilution suit. We responded that Congress is undoubtedly aware of how this court has construed Section 2, and we said it can change that if it likes. But until and unless it does, statutory stare decisis counsels our staying the course. And if that's not enough, though why not, then there's this. Justice Alito dissented in Allen in a way that prefigured today's opinion, proposing there that the jingles framework be changed to reflect his own views about Section 2's text and constitutional context. The court noted his argument that the jingles framework should be reinterpreted and then said no. As we have explained, the court said, jingles effectuates the delicate legislative bargain that Section 2 embodies, and statutory stare decisis, the court concluded, counsels strongly in favor of not undoing that compromise. Apparently, though, statutory stare decisis is now done counseling, and it is not so much as mentioned in today's opinion. That void is more remarkable still, given Allen's own reaffirmation of jingles on the merits, even putting aside its precedential status. Just control-find for all my citations of Allen, or better yet read the opinion, and you will have a good idea of its character. In addition to awarding jingles the highest form of stare decisis protection, Allen 1. traced the history of Section 2's amendment as I have, focusing on Congress's rejection of Bolden's motive inquiry in favor of White's effects test. 2. Explained as I have how each part of the jingles framework functions and how the court has used that framework for the past 40 years in one Section 2 case after another. 3. Showed how the district court's analysis, which closely resembles the one here, conformed in all respects to jingles. And 4. Rejected the notions that the jingles framework should not apply to single-member districting or that it violates the 14th Amendment. Footnote 9. In that part of the opinion, the court took note of Justice Thomas's complaint that what the district court did here is essentially no different from what many courts have done for decades under this court's superintendence. The court's one-sentence response, that is not such a bad description of stare decisis. Carrying on. The majority's main claim for why Allen nonetheless has no relevance here is that the decision was about Alabama's specific argument that a vote dilution suit could succeed only if the state's map deviated from a race-neutral benchmark. Well, sure, Allen was about that too, and in rebuffing that argument, it used reasoning that equally discredits the new Callais requirements. Footnote 10. That is so because Alabama's proposed race-neutral benchmark and the majority's Callais requirements operate on the same mistaken logic. Alabama's premise in urging the benchmark's adoption was that race-neutral reasons for districting should defeat a Section 2 suit. The benchmark would show whether a districting plan in fact derived from such reasons or instead from impermissible race-based ones. The Callais requirements are different in form but not in function. They too are designed to disentangle race-based from race-neutral, for example partisan, reasons, on the selfsame view that Section 2 liability should attach only to the former. It is, then, not surprising that Allen's primary ground for rejecting Alabama's benchmark also defeats the Callais requirements. Allen responded that Section 2 turns on the presence of discriminatory effects, not discriminatory intent. So it would not matter that the benchmark and likewise the majority's alternative mechanism suggested race-neutral motives. Carrying on. But even put that aside. The key point here is that at every step of its multi-step analysis and in every part of its multi-part opinion, Allen reaffirmed jingles, the old jingles, with its old understanding of what Congress did when amending Section 2. So Allen, too, demands that today's majority, before mutilating jingles, possess a super special justification. And it does not have one. Not a super special justification, not a special justification, not even an ordinary decent justification. On the statute's text, the statute's constitutional context, and on historical developments post-dating the statute, the majority fails at every turn. The majority's textual analysis is long and winding, and in its crucial move, wholly non-textual. The majority tells us it will interpret the phrase less opportunity than other members of the electorate to elect representatives of their choice. It then says a number of things to no apparent effect about the component terms opportunity, other members of the electorate, and elect. And then the majority puts all that aside and begins to free solo. What the provision promises minority voters, the majority says in the critical passage, is, and is only, whatever opportunity results from the application of the state's combination of permissible criteria. Can you find that in the less opportunity phrase? What the majority means is that if the state has used non-race based criteria, whether political or non-political, to draw its districts, then Section 2 has nothing to say. Even though those criteria produce a world, think about my cracked circle district, in which minority voters compared to their white neighbors have less opportunity to elect representatives of their choice, a vote dilution claim cannot prevail. That can only happen, according to the majority's view, when the district lines arise from impermissible race-based criteria. That is, when the state's evident intent was to strip minority voters of their opportunity to elect. With that interpretation in mind, read Congress's less opportunity phrase again. It is miles away. And of course it is, because once more, the less opportunity standard was designed to focus on the results of a state practice, not on its justifications. Congress had seen again and again, when it amended Section 2 in 1982, had seen for over a century, how race-neutral election procedures, including in districting, could produce discriminatory results. Congress knew states did not have to rely on impermissible race-based criteria to minimize or cancel out minority voting strength. So when this court decided Bolden, which immunized race-neutral election procedures unless a plaintiff could produce smoking gun evidence of discriminatory intent, Congress responded. It did not, as I've described, opt for proportional representation. It enacted a standard that would take some work to meet. But it most assuredly did not amend Section 2 to give minority citizens only whatever the application of the state's combination of permissible, i.e. non-racial, criteria produced. So the majority must turn elsewhere, and it next lands on the Constitution. There it begins in settled territory. The 15th Amendment, all agree, prohibits only purposeful discrimination, but that amendment, in addition, grants Congress the power to enforce it by appropriate legislation. Even the majority concedes that grant enables Congress to go further than the amendment would, to prohibit things by legislation that the amendment itself does not. The important issue is how far and how much. And here the majority makes an unprecedented claim. It contends that to ensure compliance with the 15th Amendment, Section 2 must be construed to impose liability only when the circumstances create a strong inference of intentional discrimination. And more, the majority makes clear that the circumstances will not do so when the state can point to any remotely plausible race-neutral justification, whether political or non-political, for the district lines it has drawn. That is so regardless of how discriminatory its districting is in operation, even to the point of eliminating in one fell swoop all majority-minority districts. Footnote 11. Note that the majority's constitutional analysis is based only on the 15th Amendment and not on the 14th. I would not ordinarily think to make that blazingly obvious point, but in a second attempt to distinguish this case from Allen, the majority insists that whereas Allen did not discuss the 14th Amendment, here, by contrast, the 14th Amendment is the linchpin of this suit. That is not so, at least in any way that matters to the majority's analysis. The 14th Amendment serves as the entryway to that analysis because the suit in fact before us presents a racial gerrymandering claim. But as I have described, the majority opts to decide that 14th Amendment claim by focusing on the earlier Section 2 vote dilution claim from which it arose. The only 14th Amendment holding here is that a court may not draw race-based district lines without a compelling interest, something we have made plain many times before. The real work of this opinion is in deciding that compliance with Section 2 could not have given Louisiana a compelling interest because that provision, as construed today, did not require any change to the state's map. And that analysis is based only on Section 2 and the 15th Amendment, exactly the subjects Allen covered. Carrying on. I just called that claim unprecedented, and so it is. The majority has conjured it out of thin air. From before Section 2 was amended until today, Congress was understood to have constitutional power to ban practices resulting in unequal voting opportunities irrespective of proof of racial motive. And likewise, Congress was understood to have power to prohibit vote diluting practices even when a state could proffer some sort of plausible race neutral justification. In this court's seminal decisions, we explained that the phrase appropriate legislation in the 15th Amendment grants Congress the same broad powers expressed in the necessary and proper clause. So Congress has discretion to determine whether and what legislation is needed to secure the amendment's guarantees. And that discretion, as critical here, extends to outlawing voting practices that are discriminatory in effect without proof of intent. In explaining why, this court first underscored the connection between past discriminatory intent and present discriminatory results. Congress, we held, could decide that some unintentional state action works to freeze the effects of past purposeful discrimination. And that was not all. Congress could enact an effects test, we held, as the appropriate way of preventing current intentional discrimination, a sort of prophylactic rule responding to the risk, often made reality in American history, of a state's using ostensibly race-neutral practices to cover impermissible goals. And if those decisions are too ancient for today's majority, it should consider, again, Allen from 3 terms ago. There, Alabama made an argument, similar to the majority's, that the effects-based framework of Section 2 and Jingles too far strayed from the 15th Amendment's ban on intentional discrimination. We stomped on that objection. The prior decisions of this court, we stated, foreclose any argument that Congress may not, pursuant to Section 2 of the 15th Amendment, outlaw voting practices that are discriminatory in effect. Section 2's ban on electoral changes that are discriminatory in effect, we continued, is an appropriate method of promoting the purposes of the 15th Amendment. And if that were not enough, one final way of driving home the point. We are not persuaded by the view that the effects test of Section 2, as interpreted in Jingles, exceeds the remedial authority of Congress. Those well-established precepts permit Congress to do what Congress did when it amended Section 2, prohibit electoral schemes based on their vote-diluting effects, regardless whether a state could offer up some race-neutral explanation. Congress then knew that it possessed such enforcement power. Our decisions settling the issue were landmarks of the Civil Rights era, and Congress decided to use its authority. It did not make asserted state interests irrelevant. Those interests, indeed, had to be considered in the totality of circumstances inquiry Congress prescribed. But neither did Congress make those interests a nearly impregnable shield as the majority does today. It understood, just as the court had, that even race-neutral actions could perpetuate purposeful racial discrimination. And it realized, again in the same vein as the court, that race-neutral explanations could conceal race-based intent. Today's majority makes plain its disdain for those views. But the 15th Amendment gave the power to enforce its guarantees not to this court, but to Congress. So the majority moves on again, now to a grab bag of developments that it somehow thinks license it to rewrite a statute. The majority first summons the slogan of Shelby County, in which the court ordained itself the arbiter of when civil rights laws are no longer needed. Things have changed dramatically, today's majority echoes, pointing to increases in African American voting registration and to the success of African Americans attaining political office, particularly in the South where many Section 2 suits arise. No doubt that is so, in large measure because of the Voting Rights Act. But it is a separate question whether those gains will endure once the Act's protections are gone. And surely, but apparently not, the proper actor to answer that question is Congress. For one thing, it likely has a fuller understanding of the issue. I will be interested to see, for example, whether time will vindicate the majority's view that the great strides made in African American office holding, particularly in the South, will hold up after the issuance of this opinion. My own guess is not. But honestly, the American people pay no member of this court to make those predictive policy judgments, and more important, the Constitution does not allow us to base our decisions on them. It is for the people's representatives in Congress to decide when the nation need no longer worry about the dilution of minority voting strength. So long as Congress has not done so, and it has not, this court has no right to update a duly enacted statute on the theory that it knows better. Indeed, the majority's things have changed stance here is yet less defensible than in Shelby County. That is because Section 2, unlike the now defunct Section 5, itself responds to change, so no eternal fix is needed. Section 5 selected jurisdictions for preclearance based on past conditions, so if the provision's last authorization was many years in the past, the mechanism could appear outdated. Section 2, by contrast, does not run on historical data. Liability attaches based only on present electoral processes and the present discrimination they result in. A plaintiff must prove that the political process is not equally open to participation by all citizens at the time of suit. If he cannot, he loses. There is thus no danger, as Shelby County put it, that current burdens are not justified by current needs. Under Section 2, they must be. The Jingles preconditions yet further anchor Section 2 suits in the here and now by working as built-in sunset clauses. The first precondition is met only if a racial group is, in the present, geographically concentrated. That means as residential segregation decreases in a state, Section 2 becomes unavailable as a remedy. Similarly, the second and third preconditions can be satisfied only if voting, again in the present, is racially polarized. So as racial bloc voting recedes, Section 2 ceases to operate. And racial desegregation and depolarization are not just possible in theory, they are happening in fact and at speed in many parts of the country. Consistent with those trends, the number of successful Section 2 vote dilution suits, always fairly small, has declined every decade since the statute was amended. In short, as things change dramatically, Section 2 self-liquidates. And to a fair extent, it already has. But in the places where, because of local conditions, the law continues to work, the court has no warrant to speed its demise. Nor is the majority aided by what it terms the emergence of a full-blown two-party system in the states where Section 2 suits are most common. As to that development, the majority reiterates its persistent theme. When racially polarized voting expresses itself in different party preferences, district lines may reflect partisan rather than racial motives, and so Section 2 should drop out of the picture. But as an initial matter, the majority's newly formulated test will eliminate the lion's share of Section 2 claims even when racially polarized voting occurs within a single party, as in the Solicitor General's Harlem example discussed above. The state could not then assert a partisan gerrymandering defense, but it could invoke a host of other race-neutral justifications like incumbency protection or district continuity to ward off liability. In short, the majority's test fails to save Section 2 even for the intra-party racial disparities that the majority asserts Congress had in mind. And more fundamentally, the majority is wrong on its history. By 1982, the year of Section 2's amendment, Congress well knew that race is often correlated with party preference because that was increasingly the case. Senate hearings were replete with testimony about that growing correlation, with opponents of the House's results in language, Senator Hatch and his camp, questioning witnesses about why minority groups alone should be immune to partisan or ideological gerrymandering. But those proponents of Bolden, of course, did not get their way. The Dole proposal maintained the House's emphasis on results, not motives. So the majority's appeal to an old one-party system, like the rest of its insistence on disentangling partisanship and race, works not to uphold but instead to overthrow the bargain Congress made. The last argument about post-Jingles developments worth mentioning is also the most dispiriting. 7 years ago, this court held in Rucho v. Common Cause that claims of political gerrymandering are not justiciable in federal court. That was, in my view, an ill-considered decision whose adverse effects have never been more obvious than today as this country's two major parties compete in a race to the bottom. But to its modest credit, the Rucho court did not pretend that partisan gerrymanders were something in need of safeguarding. To the contrary, the court conceded that they were incompatible with democratic principles and lead to results that reasonably seem unjust. The court's rationale was only that federal courts lack competence to deal with gerrymanders, not that they were protected by law or beneficial as policy. Today, though, the majority straight-facedly holds that the Voting Rights Act must be brought low to make the world safe for partisan gerrymanders. For how else, the majority reasons, can we preserve the authority of states to engage in this practice than by stripping minority citizens of their rights to an equal political process? And with that, the majority as much as invites states to embark on a new round of partisan gerrymanders, and makes an already bad precedent into one still worse. It is not enough that Rucho has harmed the whole body politic. Now that decision also becomes the cudgel to diminish the rightful voting influence of its minority citizens. Part 4. Congress amended Section 2 to reverse this court's decision in Bolden that the law barred only intentional racial discrimination in voting. Based on a century of history, Congress determined that such a limited ban would not be enough to protect minority citizens' voting rights. The legislation Congress enacted to correct Bolden emerged from vigorous debate and careful compromise, based mainly on this court's decision in White. The new law denied a right to proportional representation. It focused instead on the opportunity that a given election practice granted minority citizens. But the requisite opportunity was not to be assessed by a state's intent or by its proffered justifications. Rather, the lawfulness of an election practice was to turn on its results, on whether it gave minority citizens a lesser chance than their majority neighbors to participate in politics and elect candidates. In making that choice, Congress exercised its constitutional responsibility to enforce the 15th Amendment, and when called on to interpret the new law, this court, from Jingles all the way through Allen, respected and implemented what Congress had done. Today's majority does not. Its supposed updating of Jingles overthrows Congress's decision to make Section 2 liability hinge on an electoral practice's effects on how it actually works. The new Callais requirements will effectively insulate any practice, including any districting scheme, said by a state to have any race-neutral justification. That justification can sound in traditional districting criteria, or else can sound in politics and partisanship. As to the latter, the state need do nothing more than announce a partisan gerrymander. Assuming the state has left behind no smoking gun evidence of race-based motive and almost fanciful prospect, Section 2 will play no role. Whatever results from the state's asserted justification is all its minority citizens are entitled to. Even if the state has deprived those citizens, but not their majority neighbors, of all opportunity to elect representatives of their choice, the law will not protect them. It is Bolden redux. Despite Congress's repudiation of that decision and this court's precedents honoring that rejection, the majority has made its own assessment of current needs and concluded that preventing racial vote dilution does not count among them. So once again, in the absence of proof of intentional discrimination, the right to vote gives minority citizens nothing more than the right to cast meaningless ballots. The consequences are likely to be far-reaching and grave. Today's decision renders Section 2 all but a dead letter. In states where that law continues to matter, the states still marked by residential segregation and racially polarized voting, minority voters can now be cracked out of the electoral process. The decision here is about Louisiana's District 6, but so too is it about Louisiana's District 2. And so too is it about the many other districts, particularly in the South, that in the last half-century have given minority citizens and particularly African Americans a meaningful political voice. After today, those districts exist only on sufferance and probably not for long. If other states follow Louisiana's lead, the minority citizens residing there will no longer have an equal opportunity to elect candidates of their choice. And minority representation in government institutions will sharply decline. At the first stage of this judicial project to destroy the Voting Rights Act, the court maintained that Section 5 was no longer needed because in recent decades African Americans attained political office in record numbers. At this last stage, the court's gutting of Section 2 puts that achievement in peril. I dissent because Congress elected otherwise. I dissent because the court betrays its duty to faithfully implement the great statute Congress wrote. I dissent because the court's decision will set back the foundational right Congress granted of racial equality in electoral opportunity. I dissent. That does it for the opinions of the justices, so now we'll get into the opinions of the hosts, and being that this was a pretty big and controversial case, we've got Will back to discuss.
I have returned.
So I guess we can just kind of get into it. I guess I'll let you start because your thoughts are probably a little more organized than mine are, to be honest.
Well, we'll see. But yeah, so I mean, like, so it goes, right? Like this was a case where I mean, Louisiana's been batting around back and forth for a while now.
Hmm.
I think since at least 2020 or 2022 with trying to get this districting problem right. Um been up and down to the Supreme Court at least one other time. And all of it hinges on culminates in this question of whether creating this second majority black district was unconstitutional racial gerrymander. And I think the majority, for what it's worth, the majority lays out a very compelling case for why it was. Um, you've got this problem where across the board, the standard of strict scrutiny is applied whenever the government wants to do something on the basis of a protected class, race, color, and language being the primary protected classes under Section 2 of the VRA. Um, and so the court, predominantly focuses on this Gingell's framework uh, to establish whether there's an appropriate distinction between a racial group voting as a racial bloc versus a racial group voting as a political bloc, because as was established by the court in a prior case, political gerrymandering is permissible even if it has a racial effect. Um, and that's effectively where the court went in this instance, where the plaintiffs, the people seeking to uphold the maps in this case, um, failed to demonstrate that there was a that Alito really focused on this idea of like, okay, like we have the technology, we have the data, we have the means to generate maps and show that you could do what the state in this instance is trying to do by redistricting in a way that is racially neutral and still gets the same outcome.
Right.
And Alito says like, well, they just didn't do that in this case. They were relying exclusively on this provision in Section 2 of the VRA that there be equal opportunity for for a racial minority to participate in the electoral system, and the plaintiffs in this case failed to quote disentangle race from the state's race neutral considerations, including politics. So there just wasn't a sufficient enough showing to demonstrate that this was necessary to accommodate some kind of historical racial prejudice, nor did they demonstrate that it was necessary and that there was no other alternative for uh, uh, achieving the same political outcome without appealing to race.
Right. And it kind of felt a little strange to me, because like the court decided against the state trying to uphold its map, and it's sort of funny that like Louisiana, had been litigating this case, or a case connected with this one previously, like trying to avoid drawing a second majority black district, then was kind of forced to, under sort of under threat that a lower court would draw one for them.
Mm-hmm.
And then they're trying to defend this map now because, like, well, we have it, and if we hadn't drawn it, like, the court would have drawn one for us, and so, like, Louisiana's kind of in a funny position now, and,
Yeah, they've been on both sides of this issue, and as governmental legal defense work goes,
right?
if the priorities change, then you have to defend an equal and opposite position sometimes. And yeah, it's a very weird thing to see. Uh,
Yeah, and but it did feel kind of weird, for the court to almost hold the state to sort of a brand new standard for VRA claims, which, I mean, if that's what the law is, and the court believes that the court had gotten it wrong previously, then yeah, I tend to think that like the court should the court should fix its mistakes, and I tend to care a bit less about stare decisis, which I'm sure we'll get into later because that was a big like focus of the dissent. But I don't know, it still felt a little weird because I'm like, man, this feels kind of unfair. But sometimes I guess that's just how it goes.
No, yeah, the court is very much like giving states something new to work with here.
Yeah.
This isn't just a reinforcement of some pre-existing principle, like uh, although there is some of that in there, right? Which we'll get into, especially as we talk about the dissent. Um, Alito here is very much like establishing a heightened standard for bringing Section 2 claims, um, a heightened standard of proof for the plaintiffs, for a plaintiff in this case, to show that there was, um, or rather that there was not, racial discrimination in the government's reasoning.
Right. And I guess one other thing that I want to note, because this is I feel like a little confusing, and there was some back and forth about this between the majority and the dissent. So there is a distinction between racial gerrymandering claims under the 14th Amendment and vote dilution claims under the 15th Amendment and the Voting Rights Act. And obviously they're going to be quite similar, especially when vote dilution is being achieved through redistricting and gerrymandering. So this, as I understand it, this case arose out of a racial gerrymandering claim under the 14th Amendment, with some parties saying Louisiana's creation of a second majority minority district was an unconstitutional racial gerrymander. And the court is deciding that 14th Amendment question by saying that, by deciding that, okay, yes, the state relied on race, like unquestionably, admittedly relied on race in redistricting. Like Louisiana didn't hide the ball on this. And they can satisfy strict scrutiny by appealing to compliance with the Voting Rights Act as a compelling state interest. However, the Voting Rights Act, as properly understood, which then the proper understanding is what most of the opinion is dedicated to,
Yeah.
doesn't justify Louisiana's map here. And so it's a little confusing because most of the opinion is dedicated to the VRA and the 15th Amendment, but at bottom this is a 14th Amendment claim, I guess.
Yeah, and it sort of indicates, sort of really illustrates how, like, at the Supreme Court level in particular, uh, they can take the legal reasoning to a logical conclusion that might not have been anticipated by either party. Although, of course, Louisiana cites in its briefings, the VRA, its reliance on the VRA. But you're right, like this claim was originally a 14th Amendment claim. What the Supreme Court has done now, not uniquely in this case, but certainly reinforcing by this case, has drawn a direct line of between the 14th Amendment and a state's reliance on the VRA, where
Hmm.
these claims are sufficiently related so that we can talk about the latter based on a claim centered on the former.
Right. So yeah, I guess um that that kind of like background or preliminary discussion out of the way, to get to sort of the majority and the its legal reasoning. I mean, I agree with what you said earlier. I think the majority sets out a fairly compelling case. I do feel like its attempts to sort of harmonize with some of the court's previous precedents are a little strained, and the its reading of the VRA just from the text of the statute again is a little strained. But I think the court makes a compelling case that that sort of strained reading is required in order to harmonize with the 15th Amendment and its enforcement clause. That said, I think the dissent also, at least states its legal position quite well, but I think
Yeah.
I was more convinced by the majority.
Yeah, this was an instance where I think that there is on both sides, I think that there is a departure from the kind of strict textualism that you and
Mhm.
I have agreed is competent jurisprudence in past discussions. Because Section 2 of the VRA, um, it uses this language of a results based orientation, and you kind of get that as well from like the historical discussions from the VRA. I believe the dissent talks about the 1982 amendments that were
Mhm.
intentionally trying to get away from an intent based reading of racial discrimination in the VRA. But then also, there's I think that there's enough, not per se ambiguity, but enough wiggle room within the VRA for the court in the majority in this instance to step in and say, well, you know, what it means for an outcome to result in racial discrimination. The standards for evaluating that need to be articulated, and they're not articulated by the VRA. So we're going to say them here. We're going to establish the standard of proof that is required.
Right, the majority kinda yeah, I mean, the dissent accuses the majority of, like, trying to basically reread an intent, requirement into the VRA, which yeah, I mean, the dissent makes a very compelling case that the the history of the VRA makes very clear it was intended to rebut the court's, like, prior interpretation of a predecessor statute as requiring a showing of intent. But I think it's more accurate to say what the majority is trying to do is sort of articulate the effects test in the VRA as requiring racial discriminatory effects, qua race, right? Like as the majority says, like repeatedly, disentangling race from politics. Like you can have like politically discriminatory effects that wind up producing incidentally racial disparities, and the majority says no, 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 that's not enough. You need to show that these effects are the product of racial discrimination as such, I guess.
Yes, and there's because this case focuses in particular on a majority black district in Louisiana. We can narrow our focus for like that political analysis to black voters in Louisiana, which generally, if not overwhelmingly, vote Democrat, right? That's not a universal principle across the country for every minority group or for black majority districts in general. But it is a trend that we can observe in Louisiana. And which is why this I think creates such a difficult problem for the court and for the VRA itself. This is a bit of departure from the opinion itself. I'm just saying what I think. It creates a problem because there is such a concentricity, it, such an overlap between uh, black voters in Louisiana voting as a racial bloc and them voting as a political bloc, where it almost ceases to be even cognizable how you could politically gerrymander uh, uh, Louisiana to be more favorable to Republicans without racially gerrymandering it to be less favorable to black voters. And to that end, I think that insofar as you're willing to accept political gerrymandering, you have to accept racial gerrymandering, or at least in effect. Uh, and you know, I have a lot of opinions about how districts are drawn and whether or not we should have political districts in the first place. But all of that aside, right? I'm actually generally pretty content with the idea that yeah, if political bodies like the legislature are allowed to decide whose voters are where, in order to give them a advantage to one side of the aisle or the other, then you have to accept that in communities or in states, in political subdivisions with a relatively politically homogenous racial group, that racial group is going to get diluted. uh, the only alternative is doing exactly what the VRA explicitly does not advocate for, which is the creation of a right for protected classes to have proportional representation.
Right. And I kind of struggle to see how like the dissent's reading of equal opportunity doesn't produce that result because it seems to me that the dissent reads equal opportunity to mean like your gerrymandering can't produce or your redistricting or whatever can't produce racial disparities, even if those racial disparities are entirely incidental to uh political efforts or political advantage. And yeah, I mean that seems to me to just necessarily result in, well, racial minorities get, or I guess racial groups in general get a number of districts roughly in proportion to their population, because otherwise, well, we've got an unequal opportunity to elect representatives of our choice.
Yeah, I think that both the majority and the dissent in this case, that is a weakness of the arguments that were presented, was a sort of taking for granted or a failure to really flesh out how you actually distinguish racial discrimination from political discrimination. There's
Yeah,
sort of a lot of the opinion of the entirety of the opinion, majority through dissent, sort of takes for granted that we should know the difference. And I think that especially under circumstances like Louisiana, that distinction can be really blurry.
yeah. I mean, I think the majority does a reasonably good job trying to set out a standard that disentangles the two. There are definitely some questions left open as the dissent points out, but I don't know, there's always questions left open, so like, if they need answered, they could be answered in a later case, I guess is sort of my was sort of my conclusion on that, but yeah, I to sort of return, I guess, to the legal arguments I sort of alluded to earlier, I did think the strongest argument for the majority was the on the 15th Amendment and the enforcement clause, and that Section 2 of the VRA, as previously understood, would have, I guess for lack of a better phrase, gone too far in enforcing the 15th Amendment, by, as the majority says, enforcing a right that the 15th Amendment doesn't guarantee. And yeah, it can be difficult to draw the line when a law enforcing the 15th Amendment or any of these other amendments that explicitly empower Congress to enforce them by quote unquote appropriate legislation. It's like, okay, well, when is it not appropriate? Not always clear. But like the court does kind of have to set that line because this can't just be an open ended grant of authority to Congress to do whatever it
Yeah,
wants, so long as it's, sort of connected. Like,
yeah. No grants of carte blanche legislative authority.
right.
We try to read the Constitution to not do that.
Right, and yeah, that can be, difficult with clauses like the necessary and proper clause or enforced by appropriate legislation, etcetera. Um, but yeah, I think the majority makes a compelling case that, like, well, the 15th Amendment prohibits intentional racial discrimination, and obviously the VRA goes further than that, and it can go somewhat further than that, in trying to flush out intentional racial discrimination. It doesn't necessarily have to just prohibit that, but it can't go so far as to reach, you know, totally, at least constitutionally, innocent conduct like partisan gerrymandering. And the sort of prior interpretation of the Voting Rights Act makes it really, really easy, the majority argues, and I think I agree, for plaintiffs to effectively bring partisan gerrymandering claims under the guise of vote dilution claims.
Yeah. I thought that was a really compelling point. Yeah, where's the quote here? I have the quote. A litigant can easily exploit Section 2 for partisan purposes by, quote, repackaging a partisan gerrymandering claim as a racial gerrymandering claim. And that the majority here is rearticulating what I've already expressed, which is that there's there's so much overlap in under these circumstances that it's only logical that as a litigation strategy, an aggrieved party or a supposedly aggrieved party would attempt to make the argument that is constitutionally more likely to succeed.
Right. Yeah, I mean, especially after Rucho, like, the court has made pretty clear, yeah, we're not doing partisan gerrymandering stuff under the Constitution. Go away.
I I I enjoyed the concurrence,
Yes, I
short
did,
that it was. I think I think the distinction that Thomas draws, or rather the position that the Section 2 should not be applied to districting. I think that that makes sense, especially with a strictly textual reading of the law.
Mhm.
Um, and I think there's some wiggle room. There's no strict delineation between the rules and regulations that dictate ballot access from the rules and regulations that dictate uh, uh, voting districts. But certainly, there's something to be said there that that the VRA, as written, does not clearly uh, is not clearly meant to be applied to the redistricting question.
Yeah, I know that, that has been a longstanding position of Thomas, and, um, I haven't really looked into it as much as I should, but yeah, I think there is definitely a textual case to be made, and like I'll be honest, the fact that Gorsuch joins this one kind of gives me a little more confidence that this isn't just one of those Thomas is being weird moments. Um, because I mean, and to be clear, like Thomas being weird isn't always like, hey, I disagree. Like sometimes I like when Thomas is weird, um, but yeah, I think I can see it. Honestly, I totally forgot that the concurrence existed because it is literally 2 pages out of 92.
Yeah,
And
it's barely worth a footnote, but I wanted to mention it because they say I think it's implicit in the Alito opinion, or rather, it's not it's not something that the majority wanted to decide.
Mhm.
Uh, but I think that it's logically inferable from, or it's logically, compatible with the majority. It's just something that the majority didn't articulate. So Thomas takes the time to just be like, "Hey, by the way, while we're in this space, probably shouldn't even apply to districting anyway." Like
Yeah,
the districting's yeah.
I think the majority, just sort of, like, says, "We're assuming this for the sake of argument."
Mhm.
And actually, I don't even think it was that, like, I don't even think it was that explicit about it. It just kinda said, like, "Well, assuming this," and, didn't even give it a full sentence on its own, um, but yeah, I was trying to find the language, that Thomas refers to, because yeah, he says, "A voting qualification, prerequisite to voting, or standard practice or procedure." Yeah, I mean, a district map is definitely not a voting qualification. It's you have to really stretch to argue it's a prerequisite to voting. And so then it's gotta be a standard practice or procedure, and that seems like a weird way to encompass drawing district maps. Yeah, especially because, like, you've already got language in the Constitution that all agree encapsulates drawing district maps, that being, setting the times, places, and manner of electing, representatives and senators. Yeah, I think reading back over the very short opinion, I'm even more, convinced that Thomas is probably right. But
which I think just goes back to again move away from the opinion and more to just my space of personal opinion. I think it really speaks to the weakness of the VRA. We talk about it, and for many real historical, practical, political, legal reasons, the VRA was slash is a phenomenal piece of legislation. Uh, but it does not achieve for all of time what the kind of zeitgeist, the kind of perception that we project onto it. Uh, it doesn't protect districting. It doesn't, you know, protect the political uniformity of a racial group. And that isn't to say that it should. I'm just saying it's like we, and by we I mean more or less the courts, cannot simultaneously be the interpreters of the law and a bulwark against the degradation of a law's meaning and utility over time. Like the court does not get to modify the law in order to make it continue to be relevant. That's exactly what Congress is supposed to do. And I think that to a greater or lesser extent, for better or for worse, the Supreme Court is doing its job by pointing out the precise methodological and historical weaknesses that the VRA has with respect to our constitutional, uh, the constitutional rules that control,
Mhm.
that preempt. I would really like to see Congress take a proactive role in reforming laws like the VRA, not just by, superficially modifying some of the language, inserting new clauses or new like subsections or whatever, but actually just like fully rewriting it so that we can achieve functionally the same ends without inviting all of these fairly obvious dilemmas, all these fairly obvious weaknesses back into the law.
Yeah.
I'll get off my soapbox.
Yeah, I would agree, and honestly, I was kinda I'll be honest, I was a little surprised to hear the that sort of framing from you that, like, yeah, the courts can't re like, rewrite the laws or change the laws to ensure that they're relevant. Not that I think that you would believe the opposite. Like, I don't know, I'm surprised that there's as much agreement as there is, between us on this case, which is
Well,
cool.
yeah, I think that it's just, in terms of the spectrum, I'm just further along the side of the court changing things than you are, but I'm certainly not on the opposite end of the midpoint. You know,
Mhm.
I definitely because I want to have faith in our legislative branch to be able to do a goddamn thing. I can appreciate, at least in the abstract, uh the the idealistic belief perhaps that the court has a domain and it should stick to that domain.
Right.
You cannot reinterpret the entire language of a bill, of a law, in order to make it workable under the set of facts that you're faced with. uh Insofar as uh statutory interpretation is like an exercise in flexibility, there is absolutely a point where the thing you are bending breaks. And the maybe not in particular this case, but just in general, uh, you see that happen a lot. I think where the court argues so far in that one direction. Uh, the typically the liberal justices, because they're the ones who are more open to an evolving understanding of the law, um, where they want to reconstrue something so immensely or so quickly that it it ceases to function, I think, in a
Mm.
meaningful way.
Yeah, I don't know, I just I thought it was, sort of a I don't know, not quite ironic, but for lack of a better word, ironic, like, framing, because, like, the dissent very much accuses the court of sort of doing exactly that, of, basically rejecting the balance that Congress struck, rewriting the law, etcetera. So I was like, I don't know, it was sort of funny in my head, but one one last sort of thing that, I wanted to mention about, like, the legal reasoning, especially, like, the constitutional reasoning from the 15th Amendment is, something that occurred to me while I was reading the opinions and kinda creates a bit of a wrinkle, to me is, so like I said, the most compelling part of the majority, I thought, was that reasoning from the 15th Amendment and, okay, this isn't appropriate, it goes too far, it reaches too broadly. But at least as applied to redistricting, the elections clause sort of makes or creates a bit of a wrinkle in my head because, at least as I had understood it, the elections clause, which reserves to the states the power to make regulations as to the times, places, and manner of holding elections for House representatives and senators, but then grants Congress power to sort of override those laws and make its own regulations and alterations. Like, I had understood that, okay, that essentially gives Congress almost a blank check to set the laws for redistricting. And so, if you're saying, oh, well, this law goes too far as to redistricting, it's like, but then couldn't you just assert power under the elections clause? And maybe it's just, oh, well, that wasn't an argument pressed, or this law wasn't passed in reliance on the elections clause or something. I don't know. But it's I don't know, like I said, it's a bit of a wrinkle in my head and I can't get over it.
I think what it comes back to, at least if I was going to argue for consistency, I think what it comes back to is that again, this problem of like the way that the VRA is written. It's not so much some kind of abstract reliance on the elections clause, but literally and directly that Congress did not put an establishment of regulations regarding the time, place, and manner of elections into the VRA. It did not explicate
Mm.
redistricting rules with respect to um, minority groups and minority districts. Uh, a superior VRA would have done that. uh, but I think that it kind of speaks to the majority's interpretation, and in particular the concurrence's interpretation, that the VRA doesn't have to do with redistricting because it doesn't establish a framework for evaluating redistricting. At least Section 2 doesn't,
Right.
right? Like there's analogies and the sort of when the VRA was put in place, obviously the regulation of particular states that needed to have their redistricting decisions validated by a court to show that they weren't being done in a way that is racially discriminatory.
Mhm.
But Section 2 doesn't, it doesn't speak to that directly enough for it to be clearly intended or clearly established by Congress pursuant to the elections clause.
Right, so, yeah, essentially, it's not like the law is not, passed as an exercise of Congress's elections clause powers, and, if you subscribe to the Thomas Gorsuch, textual position that it doesn't regulate redistricting at all, then there isn't even an elections clause hook in the first place. Okay. That sort of that irons out that wrinkle a little bit.
Yeah, I mean, like kudos for catching that because I think it is something that again the court could have done better to explicate or uh, uh, it creates more room for future cases to sort of make arguments pursuant to. Um, but my position, as I believe has already been articulated, is that the VRA just didn't do that,
Right.
and a superiorly written successor law would do that.
Yeah, I mean, I don't know, the whole time I was thinking about that elections clause thing, I was like, "I have to be missing something because nobody addresses it, nobody talks about it." Like, okay, clearly I'm, like, off doing my own thing somehow or but yeah, I guess to, sort of move on to the dissent, not really much to do with the legal reasoning, but, I did sort of dislike the dissent a little bit for some of the same reasons that, I disliked Jackson's, I think it was concurrence in Trump versus Barbara. I don't think it was nearly I don't think it was nearly that or as bad in that respect, but it did feel like Kagan was approximately equally concerned with making substantive legal points and substantive legal arguments and expressing righteous indignation at the majority. Um,
Yeah, Kagan used a lot of this, like, "This decision is grave," Section 2 is dead letter, talking about, the literal blood of Union soldiers and civil rights marches to frame, like, this decision in a negative light, which, you and I, again, we agree that this kind of flowery, waxing poetic, it isn't while it might be useful to convincing the reader about your position, it isn't necessary or good for purposes of the legal argument that our Supreme Court is supposed to be making. All that said, you know, you and I do agree that Kagan also does directly address the legal issues that the dissent takes with this decision.
right, and I think she makes her, legal argument well. Like, I reading her opinion, I definitely had to I don't know, because sometimes you'll read a dissent and or at least I'll read a dissent and I'll be like, "Yeah, I don't have to try very hard to understand, like, how you're still wrong." Even, reading all of this, like, I can make rebuttals to it and, defend the majority's reasoning. I had to think a little harder to defend the majority's reasoning from Kagan's dissent, I felt like. So, like, it was well written, it was well reasoned. Um, I think the majority still, like I said, made a more compelling case, and yeah, I didn't like the flowery rhetoric and stuff, uh, but yeah, one thing that I did find kind of funny, was her, like, repeated references to Allen versus Milligan and sort of the inconsistency between Allen and this case. And I think the majority, like, tries to kinda distinguish Allen, and I think does an okay job at it. But I had forgotten who wrote Allen versus Milligan, so I was like, "Okay, was this, like, another Alito opinion or something?" No, he was in dissent in Allen versus Milligan, and it was Robert's opinion, and when I saw that, I was like, "Oh, okay, that's probably just Roberts being Roberts." Like, let's be honest, he's not always the most consistent.
No, yeah, it's a testament to the evolving the shifting, I shouldn't say necessarily evolving, but the shifting nature of Supreme Court opinion. Uh, who writes the majority opinion, and the breakup of the court on that opinion uh, can make it seem like the court is vacillating quickly between two incompatible positions. Um, but I think that Allen v. Milligan is a good example, not just of like, okay, well, that was a Roberts opinion, and so like Roberts has been known to change his mind, depending on the facts presented, but also like that was a narrowly decided case, right? Like Allen v.
Hmm,
Milligan, I think it was only 5-4, and it had to do with Alabama's particular redistricting issues where the facts were a little bit different. I don't see a firm incompatibility between Allen and this case. But I appreciate the dissent pointing out that there is a tension here.
Yeah. I don't think there's any I don't think there's necessarily an incompatibility between the holdings, but I think the dissent does point to some pretty plainly incompatible language from the reasoning in Allen. And to be clear, I'm not saying that Roberts is, again, I don't like to cast aspersions of partisan hackery or whatever at any of the justices, but Roberts does feel a little more willing to capitulate in certain respects to garner a majority or to be in the majority of a case because I remember looking at the breakdown of the opinions by the justices. Roberts did not author a single dissent in this term and was in the majority 95% of the time, and in the majority of non-unanimous cases 92% of the time, tied for Kavanaugh. So I'm like, okay, this
Mhm.
might just be, this might just be Roberts, not acting as a partisan actor, but being a little, sort of the politician, quote unquote, on the court. Um,
With respect to the dissent, I really resonated with this concern, the chief concern that the intent-based standard, the intent-based test that Alito is introducing or reintroducing per the dissent's argument, um, is going to make vote dilution cases really, really difficult to win.
mhm.
And like I said, I'm very sympathetic to that. I think that that's a real concern. But, and there is a but, I will step back briefly on my soapbox to say that this is a problem with districting in general.
Yeah.
Vote dilution does not just occur along racial lines, it occurs along lines of explicitly political lines, but also uh, lines that occur because of geography, because of the location of different labor industries, because of uh, any number of ways that you could politically, economically, or demographically divide up a state. Those dilution problems are occurring. And to me, the reformist, the idealist in me is just like, well, yeah, that probably means we shouldn't have districts at all. Like we're just having the wrong conversation. Uh, and what that looks like is, for the legislators to to iron out. But I think that the dissent highlights a very real problem, but it is framed in the context of this is a problem for the VRA, or excuse me, this is a problem for the majorities holding with respect to the VRA,
Mhm.
instead of this is a problem with all districts, uh, or the vast majority of districts in this country, and uh, that this is a testament to the problem of gerrymandering in general, or the problem of politicians getting to decide who their voters are in general, rather than the other way around.
Mhm.
And so like that's I guess where some of that conflict in me is with respect to this opinion is like I really just want to give full props to the dissent, but they're the box that, sorry, this is going to get a little bit bigger even. I feel like liberals tend to put themselves within the boxes that they were raised being familiar with. And in that sense, the quote unquote liberal is often conservative in many ways. It's just not in the traditionally
Mm.
uh, way that we think about conservatism. Um, jurists and politicians like Kagan or Sotomayor or Jackson, uh, they want to stand by the progressive achievements of a time past, the VRA being one of them. And so they want to preserve the sanctity of a progressive achievement of the past. But in doing so, they are locking themselves into a framing that was incomplete at the time and becomes only increasingly incomplete over time. And they fall victim to this in this dissent, where they are making an argument about voter dilution with respect to race, and that is a legitimate concern, but they don't take the next logical step, which is that vote dilution is a problem for all gerrymanders
Mm-hmm.
in all states. Um, and admittedly, if they talked about that, that would go beyond the scope of this of the question presented and beyond the scope of the ruling. So as a legal matter, I understand why they wouldn't talk about it. But it is just frustrating to me that like and this is so common within the Democrat side of the political spectrum, where you see these people making really compelling arguments for like why there needs to be systemic change, and then they cap off their argument. They end it by saying, and that's why things were better the way they were before. It's like that's why we need to keep the system around. We need to go back to the normal, back to the norm. And I'm like, the norm created the present. Why are you? Anyway, it's deeply frustrating to me. And that's all I got from reading the dissent was like I just want you to just take that next step. Just be like, anyway, I'm circling the drain at this point.
I guess to see if I sort of understand, like they're it's sort of a like not addressing the root cause kind of issue. Like, no, the problem isn't so much the weakening of the VRA over time, um, and insufficient protections against vote dilution and gerrymandering and stuff like that. Like, the problem is the system that permits or that, that enables gerrymandering in the first place, that being that we elect congressmen according to, these districts that divide up the states. And like, you're never going to get away from that. So like, if you want to actually, uh, make a significant change, and sort of do away with this vote dilution issue, like that's kind of where your focus needs to be, not, oh no, we need to maintain the integrity of the VRA.
Yeah, because it doesn't actually achieve that goal.
Right.
I just I just don't accept the premise that if the Supreme Court upholds the VRA as it is, that we're actually protecting anybody from vote dilution, except for maybe black voters in Louisiana under this set of facts, right? Like it's not. There's no universalizability to these principles. It's just they're trying to bandage new wounds while the cause of the wounds is still allowed to wreak havoc.
Right. Yeah, I like, sort of to extend on that a little, I feel like even if the court had basically left the VRA and all the jurisprudence surrounding it intact, like there does just seem to be some tension in actually applying it. Like, it's just difficult to, because it's difficult to disentangle race and politics, and because the prior interpretation of the VRA and application of it didn't seem to really even try to disentangle the two. Like, there's always going to be this tension between uh racial and political gerrymandering and people bringing VRA claims to try and seek partisan goal, or to seek partisan advantage and whatnot. And like, that's necessarily going to be difficult for the court uh to deal with. I don't know. It's like
Yeah.
the VRA and the court's application and interpretation of it up to now was not in a good place. I guess it's not in a
Yeah, it was
sustainable
never in a good
place.
place. 'Cause and, there are alternatives that I'll follow this tangent, but then I'll be done with it. Is like there are alternatives that have already been proposed in Congress, right? I think what was it called? The Fair Representation Act or something from 2017. It's been reintroduced like every year since then. Um, it would like it would still like be a kind of redistricting, but they would be much larger multi-seat districts than these single seat districts that they do now. Um, and the districts would be designed to ensure like a more stable uh political representation, right? I think Louisiana would go from being like a two Democrat, four Republican, or no, I think it'd be one Democrat, five Republican is what it is now roughly.
Hmm.
And then it would go to a two Dem, four Republican um distribution. Because that's how the actual like voting population is made up, generally speaking. And I don't know whether the Fair Representation Act accounts for race in its evaluations, but I think it does uh, obviate the need to. The only reason that race has been since the establishment of the VRA has been such a central issue in the country is because of how we do redistricting. And redistricting was used as a tool for many years to 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 intentionally dilute the voting power of uh, Black Americans and other minority groups. Um, I don't know if I agree that that is no longer a problem, but I do agree that it is a much harder thing to discern. It is a much harder problem to establish, or to factually demonstrate in a court of law.
Yeah, and I mean, I think that definitely is I think that definitely is, like, in very large part, a product of the fact that it is a much less severe problem. Like, insofar as it is still a problem, it's much less severe than it was. Like, we're not ushering in, the post-Civil War South again, right? Like, the United States has, certainly come a long way in that respect since, well, since the post-Civil War South and even since the, ratification of the Voting Rights Act. I forgot where I was gonna go.
Yeah, sorry, I've been talking a lot more this one.
No, no, it's good.
The it's just, as expressed, the VRA just it has a very rich history, and voting rights are so important to me that this really like brings up a lot of the issues that I have had historically with previous VRA cases as well, of just like I feel like we're dancing around the core problems in trying to, like I said, preserve this salve, preserve this solution to a problem that now is 60 years old at least, right? Like the applicability of the VRA as it was originally designed, notwithstanding its amendments of more recent years. The utility of that is just not as clearly present, and it deserves an overhaul.
Yeah.
If this is the of many court decisions that motivates Congress to finally overhaul the VRA, then kudos.
That would be a sort of irony that, like, the courts, because the court has definitely, like, gradually weakened, the VRA over the course of, several decisions over several years. And so it would be sort of an irony that, like, this, uh this, like, trend would be what motivates Congress to, like, sort of strengthen or fix the VRA and make it a little more workable and effective. Um, one, this is entirely a tangent, not really related to the thing at all, but I did kind of want to bring it up because in reading the dissent, this did sort of annoy me. Kagan, I guess I'll just read the passage from the dissent. quote, poll taxes, literacy tests, good character exams, property qualifications, convoluted registration processes, all these and more, when combined with administrative discretion, effectively suppress the black vote without much affecting the white one. And reading that, the first thing that immediately came to mind, me being a Second Amendment gun nut, was Bruin, because at issue in that case was a good character requirement, administered with significant administrative discretion in granting concealed carry permits. And Kagan and the other liberal justices dissented in that case, seeking to uphold that law. And I don't know, it's just reflective of a consistent trend that I notice of not just like singling out the Second Amendment for like poor treatment, but almost like elevating voting rights above a number of other constitutional rights for favored treatment. And like I understand the importance of the ability to vote and the right to vote and whatnot, but like the Constitution just does not treat the right to vote that way. Like it is not protected to the same degree that most other constitutional rights are, because like you look in the Bill of Rights and you see in the First Amendment it's protecting a number of rights from Congress making any law whatsoever abridging those rights. The Second Amendment protecting the right to keep and bear arms in general, in whole, from infringement, full stop.
Yeah.
And then when it comes to voting rights, you've got a few provisions in the Constitution that protect the right to vote from abridgment based on age, based on sex, based on race or previous conditions of servitude and whatnot. And preserving the state and federal government's ability to abridge the right to vote in basically every other respect, because the right to vote just isn't so much it's not a natural right in the sense that these other constitutional rights are. So it annoys me to see it elevated and other constitutional rights almost degraded.
Yeah. I would much prefer if there was some kind of normative consistency on these issues, right? If you're going to argue that that character, right, character exams, for instance, character examinations are valid for the Second Amendment, then you have to admit, at least tacitly, that they're acceptable for voting rights. I don't
Right.
for either. So I think that you should be able to maintain that level of consistency with respect to constitutional rights as articulated. I think that, notwithstanding the difference in language and presentation in the Constitution, I think that there is no meaningful distinction between the natural right to vote and the natural right to protect yourself pursuant to the Second Amendment. And so don't, and that's just what I think, right? But I was like, so don't don't use these examples, these historical examples of voting rights infringements in demonstrating the callousness and the impropriety, the evils, if you will, of the past restrictions on individuals' right to vote, if you're not willing to do the same thing on current restrictions on individuals' right to keep and bear arms. And that's just constitutional interpretation. Like, you want to be ideologically consistent. If you think that the Constitution should be something else, should say something else, should be something else, like, go for it. But your job on the Supreme Court should be to maintain ideological consistency in your decision making, and there's certainly some tension there. That I certainly agree that is just frustrating to not recognize the hypocrisy in how you're presenting these two different issues.
Well, and especially because like restrictions on the right to arms and the right to vote, like they do sort of share a similar historical or historically racist pedigree in a lot of respects.
No, I agree. Yeah, there's been as much when it comes to any right that we nowadays recognize as enshrined by the Constitution, those rights have been systematically challenged or denied to um, racial minorities throughout our country's history. So, like, there's plenty of grounds there to draw a strict analogy between the two. I absolutely agree.
Then I guess the last thing that I had thought to bring up at least was, I guess, the consequences of this decision. The dissent, does what dissents often do. Uh, Sort of predicts that the sky will fall. Not as bad as uh we've seen in the past, but there is a bit of that, sort of parade of horribles, and you know, black uh black voters will see their voting power diluted, to a almost unprecedented, or to an unprecedented degree, at least in modern history. And yeah, it that didn't really come to pass. Like, even Louisiana, the state at issue in this case, if I remember correctly, it just got rid of one of its majority minority districts and kept the other one, much to the chagrin of a lot of people on the right who were like, "No, Louisiana, you could totally just get rid of the other one too and just adopt a six Republican, zero Democrat map," but it didn't.
Yeah. No, the in terms of the consequences of this decision, I was I understand, but I was frustrated when Governor Landry suspended the primary elections because they wanted to redraw the maps. Um, I was frustrated only because you know I think that a lot of people, a lot of money and time had already been dedicated to the maps as existing. But at the end of the day, I get it. If they're unconstitutional, then they shouldn't be operated on. You shouldn't be operating an election on unconstitutional maps. So, fast tracking the creation of new maps, that makes sense. You got to suspend the primary elections in that case. Um, I don't know if or when the primary election was ever like reassigned. That's not something I ever looked into or realized. Um, but I assume they are still or did already have a primary election because I think it would really suck if Louisiana um, decided more or less top down unilaterally that it was not only going to change its maps to be compliant with the decision, but also not give political minorities in the new districts an opportunity to choose their contestants for the upcoming election.
Mhm.
But that's pretty ancillary to the meat of this decision. It's just something that I know I for one followed briefly after the decision, was seeing how the literal elections were going to occur, primary to general.
Right. Yeah, and then I believe there was one other state, I can't remember which one, it might have been Alabama or Arkansas, that got up before the Supreme Court, pretty quickly following this decision. Basically, I don't remember the exact details, but effectively asking the Supreme Court, like, "Hey, let us use our new maps," like, because sort of a similar issue. The I think the state believed that their prior maps were, under this new Calais standard, unconstitutional racial gerrymanders, and we're like, "Hey, we wanna fix this, or change this or whatever." But yeah, I don't know. It does seem that a lot of people on the right were sort of excited after Calais came down because, like, oh, there's this huge opportunity to pick up more House seats in the South where the VRA, has been most in force, and some seats were picked up, but not as many as these people were hoping, and then they were, to a certain degree, not all of them, but some of them were canceled out by Democrat states redistricting in
Yeah,
kind.
And I mean, this mid-decade redistricting issue that's been going on, it was being carried out in several states well before Calais was decided.
Mhm.
Um, and so like it's sort of like Calais opened another door. Like this is the analogy I would use. If you imagine like a venue, right, with a dozen entrances, uh, what Calais did was it opened 3 more doors to a building that was already open to the public. It's like, yeah, theoretically, like, people are going to operate on this decision, and several states, did or attempted to. Um, but, it's not like there was this sudden flood of novel redistricting in response to Calais, because the redistricting war had already started. Like, and it was already being conducted in a way that was at least nominally compliant with the VRA, even under the new standards that were established by the court. Um, it's funny, I talked about how, like, Louisiana is an instance where, like, there's this clear racial issue, where black voters and Democrat voters are largely intertwined, as a voting bloc. Um, there's I think New York, Staten Island in particular, there was an example where uh, New York was not required to redraw a congressional district in Staten Island that black voters brought there. Um, I believe that conservative black voters brought in Staten Island, uh, with respect to this Calais decision. So it's not like black voters in general are like, or overwhelmingly, it's not like they're overwhelmingly across the country uh uh politically left leaning. Um and it's not like the courts are compliant to such an extent that they have to redraw every congressional district that is brought to challenge on the basis of this decision. But notwithstanding any of that, um Alabama got their redistricting, Florida, Tennessee, um, have redistricted or attempted redistricting, Texas, obviously. And yeah, you said that there are some Democratic states that have negated a lot of those gains. California is a big one. But while we're on the subject, and this will probably be my closing thought on this, it's not related directly to Calais, but this whole question of redistricting feeds back into what I've been saying this whole time, which is districts are dumb. Gerrymandering is obvious. Which is that, a lot of Democrat states have done what Republican controlled states haven't, which is created self imposed restrictions on the capacity and extent to which they can redistrict mid decade, between censuses.
Right.
And so we are definitely in the middle of a situation where Republican states, on average, are going to be more enabled to make these changes, and therefore disproportionately more likely to see advantages in the election, in future elections, because of their capacity to gerrymander whenever and more or less however they want, so long as it is on the basis of politics. Uh, Democrat states are obviously not going to be able to do that. For example, in New York, because they have rules in place that were supposed to prevent that from happening. So it's just you have Democrat states that wanted to play by what they perceived the rules to be, and so codified those rules, and Republican states that did not codify those rules, and so are able to be more flexible in their decision making, for better or for worse.
Yeah, and we covered one such, Democrat state's attempt to modify the rules in its constitution regarding redistricting, in a bonus episode, so
Exactly. Yeah.
but yeah, I think that's honestly about all I had to say about this case.
Yeah. I've exhausted my grievances, but in general, to summarize, I more or less agree with the outcome of the case. I just, I want there to be a better future for the VRA or like legislation.
Yeah, which again, just I don't know, kind of surprised me that you mostly agreed with the outcome of the case, but yeah, that's I don't know, that's cool. I like being surprised in that way.
Well, I think in many ways, I wouldn't say that I'm politically different than how I was when we were in college together, but um, in terms of my approach to jurisprudence and my approach to legal analysis, I'm definitely more moderate than I was. So it makes sense that there's going to be more overlap.
Yeah. Anyway, with all that said, if I may ask you, my friends on the other side of the screen, please like, share, comment, follow the podcast wherever you follow podcasts, and if you'd like to support it, you can do so on Patreon. The main content of the show will, of course, always remain free, but Patreon members have access to bonus and exclusive content, like the content I mentioned earlier, and they can request specific content, including other than reading Supreme Court opinions. With that, thank you for listening, and tune in for the next episode where we'll continue on through the Supreme Court's 2025 term. Until then.